Your Excellencies, ladies and gentlemen, warmly welcome to the Stockholm Symposium on Democracy and the Rule of Law. Democracy, upholding the rule of law and fundamental rights, is one of the key priorities of the Swedish presidency, which is now coming to a close in a very few days ahead. And the purpose of this symposium is to discuss, to take stock, but also to talk about ways forward in how to strengthening the fundamental role of democracy and the rule of law, as we all know, are part of the foundational values of our European Union and of our member states. And we think that this is more important than ever, given the context in which we find ourselves today, with the declining levels of democracy around the world, but also other imminent threats. My name is Göran von Sydow. I'm the director of SIEPS, the Swedish Institute for European Policy Studies, and it's my great privilege to be the moderator of what promises to be 2 very interesting days here. We have a full program with really high-level speeches that will be delivered here, great panelists that will touch upon all of the areas that we think are relevant in this very important field. But we also have a very qualified list of participants, that is you here in the room. And already at this stage, I would like to invite you to actively participate in the plenary sessions here by questions and comments from the audience, but of course also in the rest of the program outside in the coffee room or over dinner tonight. And for those of you who are invited as speakers, I know we will hear very interesting and thoughtful aspects on these topics. I also urge you to make my life a little bit easier, to try to stick to the times you've been allocated, also to allow for this discussion that we think is so important. This symposium is also live streamed on the web. And I particularly also welcome you following this live stream, be it in the sunny parts of Scandinavia that we are in or elsewhere. You're also very warmly welcome. Now, with this said, it's my great honor and privilege to welcome here the host of the symposium, Minister for EU Affairs of Sweden, Jessica Roswall.
Thank you, Göran. Dear President, dear Vice President, dear Commissioner, he's not here yet, but he will be soon. Fellow Ministers, Excellencies, ladies and gentlemen, welcome to Stockholm. Well, Stockholm is, in my opinion, showing it from its best side. It's close to midsummer, so this is how it's always in midsummer. Maybe a little rainy sometimes, but you really catch the right time. Our constitution does not copy the laws of neighboring states. We are rather a pattern to others than an imitator ourselves. Its administration favors the many instead of the few. This is why it is called a democracy. This quote comes from one of the most famous speeches in history, Pericles' funeral oration. And this speech was held more than 2,400 years ago, but parts of it might as well have been written today. Because the struggle for democracy, for a system of government that favors the many instead of the few, it's not ancient history, it's an ongoing battle. And I do think that battle is the right choice of words, since that literally that what many people of Ukraine have to endure to preserve their self-rule. The Ukrainians are fighting despite savage war crimes, despite ecological destruction, and despite nuclear threats. Despite all that, Ukraine is still ruled from Kiev, not from Moscow. If Pericles and the Athenians wrote the first chapter of history of democracy in Europe, President Zelensky and the Ukrainians are writing the current one. That is why both Ukraine and democratic values and the rule of law are among the Swedish EU presidency's priorities. Russia's brutal illegal aggression against Ukraine clearly illustrates the contrast between democracies and autocracies. And it also highlights how the EU must defend our democratic way of life. In a world where autocracies are trying to gain ground, this is essential. To preserve European values is also a way to protect European security, attract investments, and gain new partners and allies. European democracy is built on the rule of law. And judicial independence is found at the core of the rule of law. A strong rule of law with an independent judicial leads to trust both for institutions and between institutions. Such trust contribute to a stable, predictable and transparent environment. That is precisely the kind of environment that supports businesses and fosters economic growth, guarantees fundamental rights, and offers an antidote to autocracy. Building this environment begins at home. Before I joined politics, I was a lawyer working on a daily basis in Swedish courts. And I have also been a member of the Judges' Proposal Board. The board prepares proposals for judicial appointments, which is the basis for the government's decisions. And we are currently working to improve this system. To preserve and strengthen the independence of Swedish courts, a committee including every political party in the Swedish parliament has united in a proposal for constitutional amendments. And I believe that this inclusive approach and having broad consensus on issues like this are something to be proud of. A vibrant democracy will always entail different points of view on political issues. But we must always have a common view on rules of the game. Defending democracy and the rule of law in Europe is not just a matter of protecting ourselves from external threats like Russian interference. It's also about getting our own house in order. And we have a problem with rule of law in our union. And we have to react when member states in the EU decide to act in a manner that goes against our fundamental values. Not just because we want the EU to be the democratic role model on a world stage, but also because our cooperation rests on mutual trust that our common rules will be respected across the Union. We can't trust the EU's funds are handled properly in every member state. If we cannot trust the EU funds to be handled in a proper way, then the EU budget is at risk. And if we can't trust that businesses are treated equally in every member state, the single market is at risk. And if we can't trust that citizens will get a fair trial in every member state, our justice and home affair cooperation is at risk. What we have to be able to trust that our values are properly respected across the Union. And it's no secret that these values, what these values are. They are spelled out in the treaty. Human dignity, freedom, democracy, equality, rule of law, and human rights. Moreover, these values cannot be interpreted selectively. Citizens should, of course, be able to vote in elections, but also stand as candidates. Freedom from discrimination, of course, covers the basis of gender, but also sexual orientation. And all countries, of course, have their own judicial system, but all EU countries have agreed to give final jurisdiction to the European Court of Justice. These are basic principles of our cooperation, and upholding these principles is the basis of our trust. I'm happy to see journalists, try to spot some of you, see journalists and media represented here today. Because the importance of journalists to our democratic system cannot be overstated. In order to carry out their important work, they must be ensured strong legal protection against thrust and abuse. This is a matter of great importance to all of us, and this is an area where we have problems in all member states. In light of this, the Presidency has put a lot of effort into the negotiations in the Council on the European Media Freedom Act. And just a few hours ago, the ambassadors in Coreper agreed on the negotiated mandate on the Media Freedom Act. And may I just say congrats and well worked also, Vice President Jourova. We can now move forward to ensure that independent media is safeguarded across the EU. Another issue we have to address is corruption. Corruption is a disease that erodes the foundation of trust on which our union is built. It is something that we must continue to combat. Generally, the EU member states have low levels of perceived corruption, but this is not enough. To maintain trust in both our nation's national institutions and in EU institutions, we need to constantly improve our legal framework and other measures to prevent corruption. Therefore, the initiative by the Commission on the anti-corruption framework is welcomed, and we need to have an international and European cooperation to fight corruption. Democracy and rule of law are defining issues for the EU's future, and this is why we must act, all of us, to ensure that we live up to our own standards, and that is why I have invited you to this symposium. I want this to be an opportunity to take stock of where we are and how we can all contribute to strengthen democracy and the rule of law, EU institutions, member states, civil society, media, academia, legal practitioners, and others. What instruments do we have at our disposal, and how can they be best used to have greatest effect? I want this to be a high-level and engaging event. That is why we call it a symposium. But I don't want this discussion to stay in this room, as also Göran said, that all will be included. And this is why the Presidency is preparing a note with a few key takeaways that we will share with the Commission and with upcoming presidencies. Because even though we are reaching our end of this presidency and protecting rule of law and protecting democracy and the rule of law is not just a matter for us, it's a matter for all presidency, and it is indeed an ongoing battle. And at this symposium, we hope that we can provide some concrete ideas on the way forward and when we pass the torch. With that, I would like to say welcome again to Stockholm. I'm looking forward to these 2 days. Thank you.
Thank you so much, Minister Roosevelt, for that very warm welcome to all of us. Now we will proceed, and there will be a moment for questions and discussions when Jessica Roosevelt will return with the upcoming trio presidencies here in the panel A. But before that, we have no less than 2 keynote speeches to be delivered. So I would now like to welcome the President of the European Court of Justice, Koen Leenaerts, to come here to join me. And the news agency Politico, they describe President Leenaerts as the man at the center of every tricky legal issue in the European Union. And I'm sure that's an accurate description. And we had the privilege to have President Leenaerts here already in April for a conference on the very same theme. And I will now draw your attention to the booklet that you will find on your chair, which contains a contribution by President Leenaerts as well as a number of scholarly contributions. So please enjoy that. That said, I will now leave to you, President Leenaerts.
Thank you, Göran. Minister Oswald, Vice President Jourova, Commissioner Reinders, distinguished guests, ladies and gentlemen. It is my great pleasure to be able to address you today at the Stockholm Symposium organized on the timely and important topic of democracy and the rule of law, which are, as the Minister just said, in her invitation she speaks about integral parts of the European identity and cornerstones for cooperation within the Union. Indeed, Article 2 of the Treaty on the European Union defines the European Union as a union of values. Those of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. These values constitute our common heritage and stand at the very apex of the EU legal order, in which all citizens and all member states are equal. But all the member states remain also equally bound to respect those values. Within the EU system of checks and balances, the Court of Justice of the European Union, together with the national courts, ensures the full application of EU law in all member states and effective judicial protection of the rights of individuals under that law. To put it simply, the mission of the EU's judiciary, national and union level combined, is to uphold the rule of law. However, the concept of the rule of law is not a simple one. As I have written extrajudicially in a recent article in the Columbia Journal of European Law, the Court is, in the interpretation of this concept, mindful of the limits of its own competence and of its role within the EU's architecture. The Court seeks notably to draw inspiration from the constitutional traditions common to the member states, and thus makes sure that the sui generis constitutional structure of the Union, founded on and anchored in the values of Article 2 TEU, is protected at all times. In today's talk, I would like to take you on a brief jurisprudential trip down memory lane with a finish line in the present day, through which I will argue that whilst the topic of judicial independence as a core constituent of the respect for the rule of law is often perceived as a regional or an era-specific issue, but in fact it is a universal yardstick of a functioning democracy to which all member states must be and are held accountable in the same manner. It is true that the Court of Justice's case law, emphasizing respect for the rule of law, has gained a lot of attention in recent years, but it is far from novel. On the contrary, it dates back all the way to the seminal judgment in Lever against European Parliament, delivered in 1986, in which the Court of Justice captured the essence of the rule of law as the idea that neither the EU institutions nor the member states are above the law. The Court stressed that in a union based on the rule of law, the system of governance is one of law and not of man. If this fundamental value is not respected, all other values listed in Article 2 of the Treaty on European Union become empty promises. The case law focusing more specifically on the concept of judicial independence finds its origin in the Wilson ruling, a ground chamber judgment of 2006 in which I have been acting as reporting judge for the Court of Justice Ground Chamber, and it was delivered following a preliminary reference by the Luxembourg Administrative Court. The Court of Justice made clear that the concept has both an internal and an external dimension. Briefly stated, the case related to a lawyer, Graham Wilson, who had not been allowed to register on the B list of the Luxembourg Bar. And the judicial protection, judicial between quotation marks, which he enjoyed, was to go before a sort of arbitral board of the Luxembourg Bar, constituted by 4 lawyers of the A list of that very same bar, and presided by a retired judge of the Supreme Court of Luxembourg. So that court was of course not independent, because it was Graham Wilson against the Luxembourg Bar, and you have 4 judges, quote unquote, who are members of the bar and then presided by a retired judge. So the court said that this was not satisfying the judicial independence, the effective judicial protection, which the directive providing for the practice as a lawyer under the denomination of origin, that is here as a British barrister in the financial law sphere, that this was not effective judicial protection. But the court clarified there, drawing on the case law of the European Court on Human Rights, the court said internally judicial independence is intended to ensure a level playing field for the parties to the proceedings and for their competing interests. Independence requires courts to be impartial. They are at equidistance to all the parties, and the judge, without fear or favor, has only the law to be upheld. Externally, judicial independence establishes the dividing line between the political process and the courts. Courts must be shielded from any external influence or pressure that might jeopardize the independent judgment of their members as regards the proceedings before them. That protection must apply to the members of the judiciary by, for example, laying down guarantees against removal from office. After the Wilson judgment, 2006, it was only a matter of time for the question to arise as to what happens when a court or tribunal, within the meaning of EU law, sees its independence threatened by the political branches of government, and whether it could rely, such a court, on EU law in order to protect itself. This issue is a fundamental one. Without independent judges, public authorities are free to exercise their power arbitrarily, with impunity. Without independent judges, there is no cooperation with the Court of Justice of the European Union through the preliminary reference procedure, with the aim of providing effective judicial protection of the rights enshrined in Union law. Without independent judges, the Union's judicial system as a whole is weakened and the rule of law rendered meaningless in practice. Looking at those consequences, it does not come as a surprise that in the seminal judgment Associação Sindical dos Juízes Portugueses, also known as the Portuguese Judges case, the Court of Justice held that Article 19 TEU, the treaty provision imposing on the member states the obligation to provide remedies sufficient to ensure effective legal protection in the fields covered by Union law, that provision may be relied upon in order to set aside national measures that call the independence of the national judiciary into question. That case is really a paradigm shift. The lessons that can be drawn from that ruling mark a constitutional moment for the European Union, based on the rule of law. Indeed, this ruling makes it crystal clear that there is an unbreakable link between respect for the rule of law, the principle of effective judicial protection, and judicial independence. In the context of the area of freedom, security, and justice, this means that only independent judicial authorities may issue European arrest warrants. Given that the execution of those warrants, more often than not, entails limiting the fundamental rights of the person concerned, and notably his or her right to liberty, those warrants must be issued by an independent body that affords effective judicial protection to those fundamental rights. In the Polterak ruling from 2016, the Court of Justice therefore clarified that the term judicial authority cannot cover police services, which in this case happen to be Swedish police services. Nor can a European arrest warrant issued by such services be regarded as a judicial decision. Later on, in 2019, the Grand Chamber of the Court of Justice, in the cases OG and PI, Public Prosecutors' Offices of Lübeck and Zwickau, the Court of Justice held that since the German Public Prosecutors' Offices of Lübeck and Zwickau were subject to directions or instructions in a specific case from the executive, they were not independent, thereby lacking the authority under EU law to issue European arrest warrants. So I quoted here a Luxembourg case, of the Grand Duchy of Luxembourg, and a German case. I stress the point, and I pause to stress it, because the rule of law is a concern relating to all 27 member states equally. It is not a matter concerning only a few member states. Our case law bears that out. it's even-handed, it's balanced. In a union based on the rule of law, no one is above the law. That includes the union institutions. In the context of the rule of law litigation, the Court of Justice can therefore be called upon to verify whether the union institutions, when adopting measures strengthening the rule of law within the EU, respect themselves their competences as conferred on them by the treaties. In the conditionality judgments, the full court judgments of February 2022, the Court of Justice, while ruling on the merits of two annulment actions brought respectively by Hungary and Poland against Regulation 2020/2092, establishing a horizontal conditionality mechanism, shed further light on the meaning and the force of Article 2. The court held, speaking as a full court, I repeat it, the values contained in Article 2 TEU have been identified and are shared by the member states. So these values have not fallen from the blue sky. They grew grassroots bottom up. They have been deducted from the constitutional traditions common to the member states. They defined the very identity of the European Union as a common legal order. And the word identity, it is the first time that it is ever being used in the case law of the court in relation to the Union. The Union is not a state, that the court said expressly in its opinion of December 2014 on accession of the Union to the ECHR. It's not a state, but it is a common legal order and in political terms a common governance structure to manage in common between 27 member states and their peoples the policy areas which can only effectively be managed at that level. For that common legal order to function, it has an identity which expresses itself in Article 2. That identity must be seen vis-à-vis the national identity of the member states, which the Union respects, but the national identity of the member states can never go against the common identity of the Union as a common legal order. So that is really the core essence of that judgment. And the court goes on saying the European Union must be able to defend those values, but within the limits of the powers, the competences that the Union has. That's the principle of conferral. Article 2 is not merely a statement of policy guidelines and intentions. It contains values which are given concrete expression in principles containing legally binding obligations for the member states. Several important conclusions can be drawn from these passages. Firstly, the Court of Justice shed light on the legal value of the Article 2 values, what my Italian colleague Lucia Serena Rossi has very beautifully described in French, la valeur juridique des valeurs. And it's now an article in the Revue trimestrielle Le Droit Européen, which is very often referred to and for very good cause. So it's legal values. They're not merely aspirations, but a foundation of principles which impose legally binding obligations on all the member states. And that's great about the conditionality regulation, because there, on a proposal from the Commission, the European Parliament and the Council, through the ordinary legislative procedure, have spelled out 10 principles which decline and concretize, specify the value of the rule of law, and so those are very handy. So it's a very handy checklist of principles which leads to extremely concrete obligations. Secondly, the court made clear that these values are not imposed by Brussels or by Luxembourg, but as I said, are the result of a bottom-up approach, since they are inspired and fleshed out through the constitutional traditions common to all member states. The member states recognize in that article that they have these values in common, And the member states are the masters of the treaties, each member state having ratified the treaty in accordance with its own constitutional requirements. It also means that compliance with Article 2 TEU in no way imposes a particular constitutional model. As you know, there are 27 member states. 9 of them have no constitutional court, including our host member state here. That's a member state based on the rule of law. But if you have a member state with a constitutional court, that court must be independent. Thirdly, and fundamentally, the Court of Justice recalled that the very identity of the EU is based on those values. Without respect for democracy, liberty and justice, the Union as we know it would cease to exist. That is why the EU has no choice but to defend those values. That is also why, prior to accession, any candidate state for EU membership must align its own constitution and national identity with the said values. That value alignment is not only a precondition for accession, but an ongoing commitment for all the member states for the duration of their membership. Put differently, accession is the starting point in value protection, not the finish line. Indeed, EU identity and national identities are in a mutually reinforcing relationship. By protecting values contained in Article 2, EU law also protects the identities of the member states. Consequently, authoritarian drifts, cloaked in constitutional reforms, have no room in the EU, because they simultaneously betray the constitutional traditions common to the member states and undermine the identity of the EU. In that regard, I would like to wrap up our jurisprudential trip by drawing your attention to paragraph 62 to 80 of the judgment of the Court of Justice in the Commission versus Poland case, judgment delivered on the 5th of June 2023. Those paragraphs contain a concise and clear explanation as to why the Court of Justice enjoys jurisdiction to examine the compatibility with EU law of legislative reforms that target the national judiciary. The Court recalled, I quote, "Although the organization of justice in the member states falls within the competence of those member states, the fact remains that, when exercising that competence, the member states are required to comply with their obligations deriving from EU law, and in particular from Articles 2 and 19 TEU. The Court added, since the Court of Justice has exclusive jurisdiction to give the definitive interpretation of EU law, the Minister also referred to that, it is for the Court, in the exercise of that jurisdiction, to clarify the scope of the principle of the primacy of EU law in the light of the relevant provisions of that law. This means that that scope cannot depend on the interpretation of provisions of national law or on the interpretation of provisions of EU law by a national court, which is at odds with that of the Court of Justice. I conclude. Believing in democracy, liberty and justice for all, and fighting for them is both an individual choice as a human being and a collective choice as a society. In any union based on the rule of law, it is even more than a choice. It is a responsibility. The Court of Justice cannot, should not, and I believe does not stand alone in upholding the values on which the EU is founded. Deepening democracy through the rule of law must indeed be our daily joint endeavor in order for the European Union to remain a union of democracies, a union of rights, and a union of peace. Tack så mycket.
President, you can stay. If you stay 1 second, we can have a question. Well, thank you so much,
to me.
President Lennartz, for that very inspiring and also illuminating speech. Now, I've promised that there is room for questions and answers. So if you indicate to me by raising your hand, you will soon get a microphone. You can present yourself and ask a question. And of course, I understand if you're very shy and so on, and you can keep those questions for later as well. If I then take the opportunity as I stand here, if all your description that you've made throughout the speech describing this development, I was curious to think about your own institution, the European Court of Justice. Would you say that through this constitutional moments that you describe, does it also alter the role of the European Court of Justice or not?
Well, Göran, the answer is yes and no. I mean, as I tried to bear out here, is that the concern for the rule of law is 40 years old. It started vis-à-vis union institutions. In this Lever case, I was the referendar for the juge-rapporteur René Joliet, and we worked on that case. It was a case brought by the then beginning ecologist movement to get into the European Parliament, and they got less of the financing for parties to participate in the next European elections. So it was a very fundamental democratic principle of the equality of chances before the voters, right? But technically speaking, the Parliament could not be a defendant in an annulment action at that point in time. And when that obstacle was cleared, there was the further obstacle that, of course, all the newcomers who were not yet represented in the outgoing European Parliament, that was an open category where theoretically everyone could come up. So there was no direct and individual concern for the lawyers in the room, so that was an additional obstacle. And the court said, well, those are two technical limitations in the text of the treaty, but the European Union and its institutions, in this case the European Parliament, are subject to the fundamental principle of the rule of law that all their acts or failures to act, action et carence in French, they should be the possible subject matter of judicial review. And especially so when it comes to the fundamental principle of representative democracy, that at elections all the competitors must be on a level playing field at the starting line. So the court jumped these obstacles. So that is in fact an ongoing process from then onwards. And of course our predecessors in the 1980s, when they set a national judge, they said, well, of course, that judge is independent, impartial, that's protected in all the national constitutions, no further questions were asked. But then came this Luxembourgish case, and to our great astonishment, in a founding member state of the European Union, there was a huge gap in judicial independence. And in fact, it was a Luxembourg judge who saw that, because the appeal against this quasi-judicial board of 4 lawyers and presided by a retired judge of the Cour supérieure de justice, the appeal lay before the Supreme Administrative Court of Luxembourg. And it is that court which asked us, is that first instance judge really independent? So in fact, that is exactly what now happens with cases coming from Hungary, from Poland, from Romania, where judges say, is this here okay in my system? So that has happened there in Luxembourg. The German case I quoted, it was an Irish judge who refused to implement the European arrest warrant issued by German procureur, Staatsanwälte, because they said, well, they can get individual instructions of the justice minister. That's not independent. And the court said, yes, absolutely, this is not independent. So whereas the same day we were delivering a judgment involving the general procurator of Lithuania, and he was totally independent, because he was a magistrate like a judge. So you see, it's really not a matter of some member states vis-à-vis other member states. It's something which is anchored very deeply in the Union legal order itself. It draws on the constitutional traditions common to the member states, and it is absolutely even-handedly, and that's the message I want to carry here, applied vis-à-vis all member states. When we have member states where there is, for instance, judicial backlog and times of judgment which make that all or most of the criminal proceedings, for instance, to combat serious fraud with financial interests of the Union, whether it be VAT carousels or corruption and fraud in the spending of subsidies, the minister spoke about it. If that is in some member states hardly prosecuted at all because all the statute of limitations run out, this is a rule of law problem. We had such cases. So it's not new, but it is much more to the fore of the attention now, since the Portuguese judge's case. By the way, that case came from Portugal, so it's because there was a salary reduction of the judges, and these judges are judges who on a daily basis apply union law. So they say, hey, if our independence is possibly hurt, then it's also in our capacity as union law judges that it is being breached. And we said, yes, that's why we control it. In the actual fact, they lost everything because, of course, this was no threat to their independence. There had been a horizontal salary reduction for everyone, so it was not targeting the judges, and therefore there was no problem. But before saying that there was no problem, we had to establish that we were competent to say so. Yeah. And that's the important part of the judgment. Yeah. So I think that is now worked out better, but it should be understood. It's responsibility which we take on even-handedly vis-à-vis all the member states. And tomorrow night I'm flying to Poland, where I have speeches in Warsaw and in Gdańsk for the Polish Lawyers Association. That's the equivalent in Poland of the Deutscher Juristentag. And I carry the same message. This is an equally important responsibility for all our member states, and everything which we say, it's always originating from a particular member state, but our benchmarks which we develop in our case law are relevant for all the member states, and that is why the Court counts on the Commission to translate that in the rule of law scoreboards and in the policy instruments to work with that, because like any court in the world, also the Court of Justice of the European Union is dependent on other branches of government for the actual enforcement of compliance with its judgments. It can also be done in the Council, where the member states discuss among themselves the implementation of the court's case law through a name and shame process, and that's all very effective to make it work in the field. So that's where we stand in the present context.
Thank you so much, President Lennartz, and I'm sure that we will touch upon many of these areas in the coming discussions. Another applause for President Lennartz. Thank you.
Thank you.
And it is now my privilege to move on to the next distinguished speaker. I welcome Vice President Vera Jourova of the European Commission on stage. The Vice President for Values and Transparency is responsible for issues on democracy, rule of law, of course, disinformation, media pluralism. In the previous commission, she served as Commissioner for Justice, Consumers and Gender Equality. It's a great honor to have you here, and we are now looking forward to hear your perspectives.
Thank you very much, Minister Roswell, President Lennartz, ladies and gentlemen, distinguished guests. First of all, I would like to thank the Swedish Presidency for organizing the event. I cannot imagine a better place than Stockholm for such topic. And you said it, Jessica, at the beginning, that you are using, or how to say it, defending the democracy and the rule of law and fundamental rights as the main priorities of the presidency. So thank you very much for that. Also, thank you for great experience. We started the presidency in Kiruna. It was -30. Now it's +35. You really want to show us that you can survive everything. So thank you for that. And also I want to thank President Lennartz for the, how did you say, jurisprudential trip. It's always so useful to hear, and always a lot to learn. So thank you for that. Well, my where is the moderator? You will stop me, yeah? Because I decided not to use the written speech and to tell you what I really want to tell you, because in fact maybe my task now is to invite you to the real European politics and the things which I really find important to share with you. Yes, we speak a lot about the democracy, rule of law and fundamental rights as the founding principles of the EU. I remember 2014-15, yes, we spoke about these principles as well, but that time it sounded like a little bit abstract principle or abstract words. We took it as something like air or something automatic, and over time it became very urgent to speak about these principles and to start promoting them and defending them. What happened in the meantime? I think that European people have a lot on their plates. Because in the previous mandate, of course, I remember the big migration flow, so the feeling of people that we are not able to regulate illegal migration. We experienced a lot of terrorist attacks. Mr. Trump in White House, a lot of elements which created some kind of uncertainty in the society. And then COVID and war came. Now, we have a big part of our society, of the citizens, who live in big uncertainty. And of course they question whether democratic system still works for them, whether it delivers guarantee of prosperous and safe life. We have to give it to them. We have to deliver as those who are in democratically elected positions. And so no more underestimation, no more taking for granted these principles, because we have to proactively, every day, have the courage and determination to defend these principles. And of course the geopolitical context now, the war in Ukraine, Russian aggressor who uses the information war to try to convince the European people that they are the victims, that they are not the aggressors. The attempt to dehumanize Ukrainians, it started after the attack on Crimea. And I deal with the topic of disinformation, so I have good data to tell you. Already since 2014, this pressure and this permanent campaign of Russians organized to attack our brains and hearts gave us the message that Ukrainians do not have the right to exist as nation. Now they are telling us the message they do not have the right to exist as people. This is where we are now. And the values which we speak about today here are so dear to our Ukrainian fellow citizens. I was in Lviv at the university. I spoke to the young people, Ukrainian students, and they told me, well, for the values such democracy and fundamental rights, we are ready to die. I can tell you I didn't hear such things at European Union universities. Thank God. Thank God. I don't call for that, but it's a big contrast. But maybe you don't want to hear the analysis from me. You would like to hear the solutions. First of all, we, to protect democracy in the EU, we came with the European Democracy Action Plan in 2020. And this plan has three pillars: the protection of media, the fight against disinformation, and the protection of free and fair elections. I will start with media. Indeed, this is my happy day because the member states, the ambassadors agreed on the very good compromise text on the Media Freedom Act. This act is here to create the safety net for the media in Europe, because we believe that media, as the pillars of democracy, need stronger protection than any other actor on European single market. I am really happy that we have such progress. The Parliament might vote on the law at the end of September. So still I see the perspective that we will have the media law adopted by the end of this mandate. Anti-SLAPP directive, well, we believe that justice system and judges should not be abused in the dirty game of silencing the journalists by means of abusive litigations. That's why I proposed also this directive. Fight against disinformation, well, this is more and more urgent because, as I said, we are now in information war. When I look at the use of disinformation, especially from Kremlin terrorist regime, but also by other powers, we see a new chapter. I will come back to Russia. The Russian disinformation, which lives with us already several years, trying to influence the public opinion, trying to decrease the support of European people to Ukraine, trying to manipulate our elections. So this disinformation campaigning was a kind of something hidden, something which was not too much visible, but now they have strong proxies in the EU. We have in EU member states political parties which fly with it, which abuse the fear of people, and which do not hesitate to repeat the lies of Kremlin, which plan to win elections. So this is a new chapter. And so I believe that our code of practice against disinformation, which is a twin arrangement with the Digital Services Act, is the practical tool to decrease the impact of disinformation on European society. Protection of elections, another big topic. We want the elections to remain the free competition of real people, of real visions, something which gives the citizens to cast their autonomous vote. What we see, hidden manipulation, especially abuse of digital ways of communication. Now we see the new threat through the AI, the chatbots and the generative AI being used. I can tell you the combination of AI and disinformation, it's a toxic cocktail for our democracy. And that's why, again, we are taking measures. I request from the digital platforms that they label the content produced by AI, that the people, the users can see that this is the product of the machine. This is not the product of the real people. I would like us to agree on the principle that the production of machines must not be protected by the freedom of speech principle. This is here for real people. We should not protect the production of machines by copyright. It sounds simple, but I think that we have to be very stubborn that the rights which we developed for the real people will remain for real people, because this is a very powerful possibility to protect us against the negative trends which we see in stemming from the world of technologies. And nothing against innovations. In Europe we want to develop digital technologies and AI, but in a safe manner, to keep this under control of the real people. You understand well the connection between the free and fair elections and the principle of protecting the rights of people, because these are connected things. We also speak today about the rule of law principle, what to add after President Lennart's. It was really a very useful thing to remind us of all the important cases which help us to define what we mean by rule of law, because in the treaty we have Article 2. I had to explain many times how we interpret Article 2, but it's not for the Commission to interpret the treaty, it's for the court. And we have a rich case law now, which gives us explanation and guiding compass so that we apply the principle and request the principle of rule of law also from the member states in the proper way. We try to define better and better the rule of law principle also in cooperation with the member states in our annual rule of law report, which covers all the member states, equal treatment, equal methodology being used. And I'm really glad that we are enriching our toolbox to protect the rule of law as a principle, because it was needed. The rule of law report is a new thing. And back to the definition, you cannot defend something you are not able to define. That's why it's so important that there is so much work already done. And infringements, I can tell you, after 9 years in the Commission, it's not my favorite work to prepare infringements. I would really like more not to have to do it. But when there is a breach, when there is a conflict of the national law and European law, we have no other choice than to start the dialogue with the member state and then, of course, to act. Conditionality principle, the regulation has been developed to protect the EU funding. It's also one of the aspects or reasons why the people are losing trust in democracy, because when they see that there might be not sufficient protection of their taxpayers' money, then of course they cannot trust the system. That's why we have the conditionality regulation and we are applying it. I know I speak too long, maybe two last comments. We are ahead of the European elections. It's the festival of European democracy, so we work very intensively with the European Cooperation Network on elections to ensure that as many citizens as possible vote in these elections, to enable the mobile citizens to cast their vote, and also to protect the electoral systems against, besides other things, cyber security threats and IT infrastructure risks. So I think that we are working, we are doing everything to have the free and fair elections next year in June. Last comment on the future. I think that we have made so much progress, including by adopting and putting into practice the budget conditionality regulation. And following on that example, we should consider whether dramatic systemic deficiencies in the rule of law in one member state in the form of a lack of an independent judiciary leading to an absolute capture of the justice system could be the reason to suspend the internal market in that member state. As you know, the internal market is based on the principle of mutual trust. Mutual trust that the rules will be applied in the same way in all member states, and if they are not, an independent judiciary will come and correct the matter. But if the judiciary is not independent, there is no guarantee that if the rules are not applied in the same way, this will be efficiently corrected. And therefore, there cannot be any mutual trust and thus no mutual recognition. And this is a reflection we need to start for extremely serious cases of backsliding. Ladies and gentlemen, thank you very much for your attention. I said what I wanted to say, and now I'm available for the questions. Thank you very much.
Well, thank you so much, Vice President. I think what you said was very clear and also very broad and very informative. Now I'm looking again to the auditorium to see if anyone would like to challenge the Vice President or indeed pose a question to the Vice President of the Commission regarding this broad statement. And if not, that's not the case, then I will seize the opportunity and use the role as the moderator to perhaps challenge you a little bit looking forward. You indeed pointed to many of the instruments that we now have in place, and one of the purposes of this symposium is to look a little bit how can we use them more effectively. And in your view, is there anything of all these measures and instruments and areas that you've touched upon where you think, here maybe we should do a little bit more or a little bit different?
Maybe a little bit, if not better, but in a stable and predictable way. Maybe I will surprise you, but I speak on behalf of the Commission. We have new tools in our hands. And we have also to pay attention to comply with the rule of law ourselves. And sometimes when I read the resolutions of the European Parliament which can go further, I always think, well, let's keep the role of the Commission very clear and very stable. We have the competencies given by the treaty. If we want to enlarge the toolbox to protect fundamental rights, rule of law, democracy, we always have to go through very complicated and demanding process to get a yes from all the democratically elected actors. And so I would really wish, as somebody who will leave the Commission next year, I would really dearly wish that it remains the case.
Excellent. Thank you so much, Vice President. Another applause for you. Now, this is the moment where I have a short instruction to you, all of you here. That is to stand up for 1 or 2 minutes and just move a little bit, but don't leave the room, right? And we will just reshuffle up here, so please just move a little bit without any further instructions on precisely how to do it. Excellencies, ladies and gentlemen, it's really warming to hear the buzz in the room, and I think you're all now into complex issues of democracy and rule of law in your discussions, and that's something we of course encourage at this symposium. However, we need to move on, and we are now going into the panel A, Presidency Perspectives and Priorities. Now, unfortunately, we had a late minute change in the program, as Minister Lahbib of Belgium could not be here due to other unforeseen actions, so she had to be in Parliament. However, we are very happy that she will be replaced by Ambassador Andy Detaille, who is the Belgian ambassador for the rule of law. So he will be later on in this panel. We will hear from the current presidency as well as the next trio of presidency, but before that, I am very happy to introduce Commissioner of Justice Didier Reynders here to join me on stage. Give him an applause. Our first speaker is Commissioner for Justice, and of course he has a very broad responsibility within the Commission, covering issues, of course, concerning the rule of law and how to uphold it and what to do in case of breaches. And he will now give an introduction, after which we will have a panel discussion. The floor is yours, Commissioner.
No, thank you very much, and dear Minister Oswald, dear Jessica, dear Minister Varga, dear State Secretary Navarro Rios, dear Ambassador Detaille, dear President of the Court of Justice, dear Kuhn, ladies and gentlemen, it's a pleasure to be here again to take part in such a symposium on the rule of law and democracy. We have started on Monday in Stockholm with a conference in the Riksdag, in the Parliament, with many parliamentarians from different member states, and we continue now, and in between we have discussed the same kind of topics with our partners from the US, so Justice and Home Affairs responsible at the US side, and you know that we are like-minded partners with the US when we are speaking about the rule of law, democracy and fundamental rights. We don't have exactly the same way to interpret that, but we are working with the same goals and the same respect for those principles. But of course it's very important to have the opportunity to discuss on the rule of law in the EU with different members of the Council and certainly the members in charge now or in the future of the Presidency. And thank you, Jessica, for organizing such a symposium and to give us the opportunity to exchange on this. And of course it was already said today, the rule of law and democracy are among the common values set out in Article 2 of the Treaty on the European Union. But this is more than a statement of intention or policy guidance. As the Court of Justice reminded us very recently, and some minutes ago, the President of the Court of Justice, the value of the rule of law is an integral part of the very identity of the European Union. And indeed, the European Union, this may be surprising for some, has an identity. And this identity is built upon our common values. Accession to the EU was the free choice of every member state. It has not been imposed on any of them, and I want to say that sometimes the ratification of the treaty was organized in the Parliament, sometimes by referendum, so it's sometimes a real decision of the entire population to take part. And as the President Lennart put it, acquiring the status of member state is a constitutional moment for the state concerned, since at that very moment the legal order of the new member state is deemed to uphold the values on which the EU is funded. In other words, respect for those values is what being a member state of the EU is all about. And these values are what we stand for. But it's true that we have seen since the 24th February last year that the Ukrainian people are fighting for these exact same values. And so it's very important to see that we are sharing the same approach with maybe future members of the European Union, because we have started the accession process. Russia's unjustified military aggression is a tragic reminder of the consequences that the absence of the rule of law in a country can have including for the international community as a whole. This reminds us that we cannot take our values for granted. We need to stand up for them, protect and promote them. And there is no EU member state in which it is not useful and sometimes necessary to discuss the rule of law situation. All member states can learn from each other. This is why, over the past few years, the Council established a new form of rule of law dialogue. It is based on the annual rule of law report. As a preventive instrument, the report assesses the rule of law situation in each member state. It helps us to understand emerging problems before they get deeply entrenched. This report is a central part of our joint effort to foster a real rule of law dialogue among the member states. We try, in fact, to create a rule of law culture across the Union, and not only with the government, not only with the Parliament, but with the civil society, and at the end with all the citizens in the EU. A dialogue that is also held with the European Parliament, of course, and inside each member state, I said, with national institutions, citizens and stakeholders. And the role of the rotating Council presidencies is crucial in that respect. So thanks for the opportunity to discuss with the actual and the future presidencies about that. Since 2020, every presidency organized such a rule of law dialogue in the General Affairs Council. There is twice per year a country-specific dialogue covering 5 member states in their protocol order, and once a year a general discussion on the rule of law situation in the European Union. The country-specific discussion under the Swedish presidency took place at the end of March. We discussed about the situation in Finland, Slovakia, Belgium, Bulgaria and Czechia. This confirmed once again the constructive and open-minded spirit in which ministers are engaging in those discussions. And I want to congratulate the Swedish presidency in particular for 2 achievements. You did not only close the circle of the first round of discussions opened by the German presidency in 2020, you also started a new cycle. So now we are in a real cycle about the rule of law with the publication of the report, the discussion in the Council, but also about the situation in all the member states. And I want to add, but just among us, that I try to do the same with the Parliament. For the moment, it's impossible to organize a debate on all the different member states, but maybe after the summer we'll start the same kind of process to have a discussion not only on some member states but on all, because it's true that our goal is to assess the situation in the 27 member states on an equal footing with the same methodology and the same possibility to discuss such a situation. As of early July, Spain will preside the Council, and we are grateful for its commitment to put the defense of our common values, including the rule of law, high on the agenda. The Commission will support the Spanish presidency wherever we can. To start with, in early July, the Commission will adopt its 4th rule of law report and provide a fresh basis for the next rule of law dialogue in the General Affairs Council under the incoming presidency. And we are also looking forward to the evaluation of the rule of law dialogue with the Spanish presidency plans to carry out. And this is an important opportunity to reflect on the future strengthening of the rule of law dialogue, notably as regards the general yearly discussion on the rule of law situation in the European Union. There are, of course, other possible discussions about the rule of law in the Council. I want to mention the ongoing Article 7 procedures. They are a reaction to serious risks to the rule of law and other EU values. These procedures may not always be an easy exercise, especially for the Council and its presidency, but they are an important safeguard against further rule of law backsliding. It is therefore important to keep the Article 7 procedures on the agenda of the Council for as long as the reasons that triggered them persist. This is why we are grateful that in May the Swedish presidency held hearings in both procedures, and I appreciate that the Spanish presidency is considering putting Article 7 on the agenda again. Hand in hand with the rule of law, democracy is another common value of the European Union, which needs to be promoted and protected. Vera Jourova has already described the challenges we face and the urgent action that is needed. Let me simply recall that 2 weeks ago, the Commission launched an infringement procedure against Poland concerning the new law on the State Committee for the Examination of Russian Interference. Following an in-depth assessment, we consider that the law unduly interferes with the democratic process. It violates the principle of democracy, the principle of legality and non-retroactivity of sanctions, and the right to an effective judicial remedy. There are also some concerns about data protection. And this unprecedented development made swift action necessary. And hopefully we have seen, since the decision to introduce an infringement procedure, it was possible for the President of the Republic in Poland to table some amendments and to start discussions about change to this law. We'll see. We are not at the end of the procedure. We'll assess that, but we have seen a first reaction. And ladies and gentlemen, the Council has become even more involved in rule of law matters from a budgetary angle. And in a former life, I was in charge of the finance department in my own country, and I must confess that I have seen that for many member states, it's very impressive to read the recommendations that we are publishing in the rule of law report. But it's sometimes more impressive to see that there are maybe some financial possible consequence for a breach of the rule of law. And it's very clear in the last months that the budgetary angle is an important one when we discuss on the rule of law. Last year, the Commission launched a procedure concerning Hungary under the budgetary conditionality regulation. And the Commission considers that the breaches of the rule of law in this member state constitute a risk to the EU budget. As a consequence, last December, the Council adopted measures proposed by the Commission to protect the Union budget in Hungary. The Council suspended 55% of the commitments under 3 programs in cohesion policy, and the Council also prohibited any new legal commitments with public interest trusts in Hungary. In parallel, the Commission proposed to the Council to adopt Hungary's Recovery and Resilience Plan, which the Council did equally at the end of last year. However, this endorsement includes the condition of a full and effective implementation of a number of so-called super milestones. This means that no payment under the Recovery and Resilience facility is possible until Hungary has implemented the milestones in question. Among those super milestones are also 4 milestones related to judicial independence. And with the Minister of Justice, Judith Varga, and we have had many contacts to negotiate those judicial milestones and then to discuss their implementation. Recently, the Hungarian Parliament adopted laws aiming to implement the judicial milestones. It's a good step in the right direction. It is, however, not the end of the process. Hungary also needs to finalize the accompanying implementation step foreseen in the Hungarian Recovery and Resilience Plan. We have seen a similar process in the case of Poland. Its Recovery and Resilience Plan includes 2 super milestones aimed to strengthen judicial independence. All this illustrates that the EU has a variety of instruments at its disposal to take decisive action where this becomes necessary. To conclude, let me recall that more than 5 years have passed since the Court of Justice issued its groundbreaking Portuguese judge's ruling. I want to insist on the fact that it's a long process, of course, the evolution of the rule of law, but it's true that since 5-6 years, we have seen a real evolution in the Court, in the European Court of Human Rights, in the Parliament, the European Parliament, but also in the Commission and now in the Council. Since then, the Commission has brought a number of rule of law related infringement procedures before the Court. And the Court has not only fully upheld the Commission's actions, it also explicitly emphasized that the rule of law is given concrete expression in principles containing legally binding obligations for the Member States. Yet, as I just described to you, the Council has equally become increasingly involved in the rule of law matters. Indeed, under the different EU instruments, the Council has a decisive role as regards both preventive and enforcement action. Another observation is also certain. There are, unfortunately, still significant rule of law related concerns that need to be addressed. This is why today's panel is a welcome opportunity to discuss how our strategic approach to the rule of law can be strengthened for the years to come. I want to thank you for your attention. I want to thank Jessica again for the organization of such a symposium. And I want to insist on the fact that the first priority for the Commission is to engage a dialogue with the Member States to improve the situation. What we want to avoid is a regression. We don't want any regression concerning the rule of law. We try to improve the situation in all the Member States. Of course, when it's impossible to reach the goal with such a dialogue, we are using other tools. But again, we want to engage a dialogue. It will be the case again today. And we want to engage a dialogue not only with the officials, but also, if I may, with civil society and with all the citizens. Because the final goal, again and again, is to install a culture of the rule of law in the Member States, maybe in the near future in some candidate countries, because it will be important for the candidate countries to fulfill all the obligation of the rule of law before to become to be new members of such a union. Thank you very much.
Thank you so much. Well, thank you so much, Commissioner Reinders, for that contribution and the perspective on improving. I'm sure that a lot of Swedish football fans just today feel that there's lots of improvement to be made also when it comes to our national team, and not to avoid a regression here in this field. And we are due to meet Belgium soon, I think. Anyway, now we've heard from the Court of Justice, we've heard from the Commission twice. Now I'm really happy to invite here as panelists 4 representatives from 4 different member states, and that is the current presidency and the trio to come. So Minister Rosvall, welcome back again, and you're staying here, Commissioner Reinders. And State Secretary Navarro, you're more than welcome as well, Ambassador Detaille, and Minister Varga. Please join us here on the stage.
We share table.
Yeah, but you have a seat.
And
I'm too short to sit.
you can stand or sit as you wish. There are no strict rules about this. So the idea behind this panel is to look a little bit at where the presidency comes in and what the council can do. And we will start with short introductions from each of the panelists to say what they feel. For you then, Minister Rosvall, what you feel that the Swedish presidency has put emphasis and done so far in this first semester.
Thank you again, Göran. And I will definitely not talk about football today. So when the government of the previous government and the Swedish Parliament started to preparing the EU presidencies, we did that together, and we had a broad agreement that democracy and rule of law should be one of our priorities. This was an obvious priority for the government, both governments, because it is a priority for Swedes. In fact, a recent Eurobarometer showed that rule of law is one of the top 3 issues that concern Swedes ahead of the next EU election. Together with the Commission, the Council has a treaty obligation to promote the Union's democratic values. And both before and during the presidency, the Council has not taken this responsibility lightly. And even though I fully understand Vera Jourova when she said that infringement is not her favorite, but I would say that in the last few years, the Council has and Commission has intensified its work on the rule of law, both when it comes to preventive and punitive measures. And when it comes to the first category, the Council has introduced the annual rule of law dialogue. And I believe, and I totally share, Didier, what you said about the dialogue. It must be, it's something that we all can learn from. But the dialogues must be held in a preventive. It's very high to when it comes to preventive tool and a path towards positive change. And the dialogue is also important because it's provide a framework where we can help to promote common rule of law culture across the EU. And me myself, I did take part of the dialogue before our presidency, and I found it very useful to exercise and look at some of our own weaknesses and what we can do to address them. And as I said, we can all learn from each other during these. And as said, during our presidency, we have concluded the first cycle of the country-specific dialogues, and also started a new one, and thereby the situation of the rule of law in all of the member states has been discussed, and seamlessly we have initiated a new cycle. The annual rule of law dialogue will be evaluating during the Spanish presidency, and I hope that it will also result in an even better and stronger instrument for constructive discussions. So I'm very glad, Pascal, that you are here representing the Spanish presidency. I'm looking really much forward to this evaluation. Because dialogue it should not be underestimated. And as Didier said, we had another discussion this Monday, which also concluded that dialogue is a very important instrument. However, in some instances, strength and determination is also necessary. So the Council decided in December last year to suspend 6.3 billion euros of EU funds to Hungary by applying the so-called conditionality regulation. As President Lennartz just explained, the judicial aspects how that was ruled. And last year, the Council also decided on tough milestones on the rule of law in some member states' recovery plans. And this means that substantial amounts of EU funds cannot be disbursed unless real reforms to strengthen the rule of law are implemented. And in my opinion, the use of budgetary instruments is a revolutionary development, and I believe it is timely to reflect on that. The Council has also continued the Article 7 procedures against Poland and Hungary, initiated by the Commission and the European Parliament, respectively. More specifically, we have conducted Article 7 hearings with both Poland and Hungary. And these hearings provide an opportunity for the Council to better understand the situation and ask questions about the rule of law in Poland and Hungary, and also an opportunity for them to explain the reforms they have been undertaking. And we believe that hearings were appropriate because of the substantial developments in Poland and Hungary in the last few months with major reforms in both countries. And it was clear to me after the hearing where my colleague Judith presented the latest development in Hungary that important steps in the right direction has indeed been taken, but still problems remains. But I also want to thank Judith for coming to Brussels in person to participate in the hearing, and I think it shows that you take this process seriously, and I know that it was widely appreciated that you attended. To conclude, in recent years, the EU institutions have explored a number of different rule of law mechanisms. And this symposium is an opportunity to have discussion on what has worked and what has not worked, as well as what should be done going forward. Among other things, I think it's absolutely essential in the light of the future enlargement. And I am convinced that we can do more, and that I'm also convinced that we need to do more, and I think that we will do more to make sure that the rule of law is upheld in all of the European Union. Thank you.
Thank you so much, Minister Rosvall. And in only 10 days, Spain will take over the rotating presidency. And State Secretary for European Union, Pascual Navarro, we are very eager to hear what you plan to do in this area, of course.
Okay, thank you very much, and thank you very much, Jessica, for the invitation for this event. I think it's an excellent idea, and we also discussed with Commissioner Reynders the possibility of making this habit in succeeding in the following presidencies, and we have the intention to repeat this kind of event. We are still considering to which level, but I think it's absolutely necessary to have this dialogue with all the institutions. All the institutions are here in the symposium. Today we listen to the president of the court and to the commission, but today and tomorrow we will listen to other institutions, and also this dialogue between member states and the institution. Particularly now is with the commission. It's one of our favorite dialogues in the rule of law. Of course, rule of law is a priority not for the future Spanish presidency or your presidency, Jessica, but it's a priority for the agenda. No, let's have a look at the agenda for the next European Council and all the issues: Ukraine, migration, and particularly the economic situation. How to strengthen the single market that you mentioned, Jessica. How intrinsically linked is rule of law to the functioning of the internal market. So everything is related one way or another to the well functioning of rule of law. When I am preparing as usual my future presidency, I am discussing with all my colleagues, and the first issue I tackle with them is always rule of law. What do you think about the files on rule of law? Which are your positions? What do you think? What do you advise us how to do it? What we are going to do is to put it on the agenda. So we are following what Jessica did in the council. I think as you mentioned, you dealt with all the procedures in the council, and I think the most proper thing to do is continuing this dialogue with the other institutions, particularly the Commission, and to go along all the procedures that we have on the Council. We are preparing the draft agendas with the Secretary General of the Council, and dialogue with the Commission, and dialogue with other member states. And rule of law, it's in every single meeting of the Council, in every single one, till the end of the year. That's the intention of the presidency. So we are having the first procedure is, of course, the report of the Commission. I think it's the basic of the essence of our discussion in the Council. Commissioner is going to present it in July, and then we will have a further discussion, more in-depth discussion this year in September. You would like to have a little bit more in-depth this time, so we accept it. I think it's absolutely necessary. One of our main tasks will be the continuation of the dialogue that we had in this semester, and to come to the dialogue will be maybe in October with the 5 new member states, and then the most important is to come to a new conclusions on the continuation of the dialogue. We are building on the presidency conclusion of the Finnish presidency, so we are hoping we will have a conclusions that will be a continuation of the discussion with your report, and then the experience that we think that everybody considering them very useful. Everybody is happy about this benchmark, and it's very useful, and everybody is satisfied. But there is a room for not only continuation but improvement, and what is the added value of this exercise. So we will come for conclusions at the end of the year, and we will present our ideas in July, and then we will come to the conclusions in December. Of course, there is Article 7 procedure. As you ask Commissioner to continue in the procedure and following what was done by you, Jessica, in your presidency, we will continue in this procedure during our presidency. We will talk with the colleagues, with the Polish and the Hungarian colleague also, to see how to handle it. But most probably in November we will have this on the agenda. So it's in every every month we are going to have a dish of rule of law, because it's important. I think it's important. It has to be on the agenda. There are other issues related to that. Vice President Jourova mentioned the action plan, which are very much the action plan for democracy. We have still some files. The Swedish presidency, you have advanced in some of them. We expect some some more. We will be very happy if we have some more results in your last council. It will, because we have afterwards the dialogue with the parliament, which is not easy. Okay, and all dossiers, institutional dossiers related to rule of law, of course, it will be very high on the agenda of our presidency. I've been here more to listen to the other institution and to listen to some colleagues are with us today, and also not only colleagues but people from think tanks, civil society, academia. It's very useful this kind of event, just to listen to them today and tomorrow, what are their expectations and what can we do during our presidency. It will be, I am here for that, just for listening. Okay, thank you.
I am sure, State Secretary, that they will give high expectations, so mind you. Now, we thought, again, in the presidency order for Belgium, it is a little bit longer away, but not that far. And for you, Ambassador de Taille, it was a very short time for preparing for coming to Stockholm. And once again, we're grateful. But tell us, what do you plan to do during your presidency?
Well, our plans are still a little bit more vague, so I will continue with a more general statement that I've been asked to deliver, Minister, if you don't mind, Commissioner, distinguished guests. First of all, Minister Labib explicitly asked me to thank you for organizing the symposium on the rule of law. It's a topic she holds very dear, as do the Belgian government and the Belgian people. And it has been said before, I think, but nevertheless, we want to stress that besides being utterly indispensable for the functioning of our union, that the rule of law, democracy, human rights are thoroughly European concepts. From the Athenian democracy to the Magna Carta, the Enlightenment, and the French revolutions, down to the constitutional democracies of today, these principles are deeply ingrained in us. They are who we are, and they are as such non-negotiable and cannot be cherry-picked. In Europe, for us, this means first and foremost respect for the European Court of Justice, respect for the European Court for Human Rights, upholding their supremacy over national law and executing their arrests promptly and unconditionally. As member states, we can also intervene before the Court of Justice in certain cases, and we call on all member states to do so, as it sends an important signal in support of the work of the Commission and of the Court. Furthermore, Belgium firmly believes in the role of the Commission as guardian of the treaties and encourages it to make full use of all the instruments at its disposal. Besides infringement procedures, the rule of law toolbox has seen some important developments in recent years with the evolution of existing instruments and the additions of new ones. The rule of law dialogue in the Council has gained even more in depth now that the yearly report of the Commission contains country-specific recommendations, and we want to thank you for that. It has developed, according to us, into a powerful vector for peer pressure and best practices. And as has been said before, our Spanish colleagues will carry out an evaluation during their presidency, and we will make sure to implement its result during ours. The horizontal conditionality mechanism, the new kid on the block, has generated an immediate impact. As a specific mechanism to protect EU funds against any kind of fraud, corruption, or conflict of interest, it has rendered appropriate measures possible at the end of last year, and is as such already a success. For its part, it will be evaluated by the European Court of Auditors in a report coming out early in our presidency, which we very much welcome. On Article 7, we can only fully agree with what Commissioner Reinders has said before. For us, it's important that Article 7 procedures keep on figuring on the Council agenda. We want also hearings to be held, and we want them to take place in the General Affairs Council until all issues are resolved, because some of these issues are not discussed in any other forum. Then, to conclude, we also think that in general it's very important to keep on looking at our democracy and rule of law toolbox with an open mind and a critical eye. because the countries who recently, and deservedly so, acquired candidate status are not all countries which necessarily have decades of tradition in democracy, rule of law, and good governance to build upon. So we owe it to their peoples and to ourselves to consistently strive to sharpen our rule of law and democracy tools and to insist on strict adherence to the Copenhagen criteria, because, as the saying goes, to prevent is better than to heal. Thank you.
Thank you so much, Ambassador De Taey. And now there will be European Parliament elections in a year from now, after which Hungary will take over the rotating presidency. Minister Varga.
Thank you very much, dear Jessica, dear Mr. Commissioner, dear colleagues, dear ladies and gentlemen. I think I could also introduce myself as your personal Article 7 coach, because I think if there's no one from Poland, from the administration in the room, it is actually only me who has real first-hand experience how rule of law procedures work in practice. I'm happen to be part of this procedure right from its birth, because when Madame Sargentini just started to draft her report in the European Parliament, I was at the time advisor in the European Parliament, so we were actually already closely following the drafting exercise. Then I became State Secretary when the report was voted, with an interesting calculation of the votes. Why the abstentions were not calculated, I know we have a court ruling which came of almost in 2 years, while the conditionality procedure was decided in 6 months. So interesting dynamics of the court, but we have a court ruling that it was a proper resolution, not counting the abstentions, because if we count the abstentions during the vote, there's no Sargentini report at all and no Article 7 at all. I have to put this first, because I have real experience, 5 years of experience, and we don't talk the talk in rule of law procedures, we walk the walk. And as a presidency, indeed, we would like to continue these rule of law discussions. Not only because we also believe that we have to uphold and strengthen our common values, which is freedom, human dignity, democracy, and rule of law. And democracy is also, for example, to respect the free choice of citizens when they are choosing a government in their member state. But also because we do think that rule of law debates are now so complex and so diverse, just ranging from different procedures. You already listed many of them, conditionality. Even in the milestones, in the recovery, there are certain rule of law-like conditions, and also the horizontal enabling criteria are also sort of rule of law-like conditions, not to mention Article 7 procedure, not to mention the rule of law review cycle of the Commission, which was actually initiated based on a presidency conclusion, because Poland and Hungary did not vote for the launch of this type of discussions in the Council, just for the sake of the records. But they are so complex that they look like a kind of a smog. I mean it, like a smog. And the Hungarian presidency here will follow the principle of measure for measure. So we will fight smog with smog, S-M-O-G. S stands for standards. Let's not forget that the rule of law is a fundamental value upon which the EU is founded. It is not a legal rule that judicial or administrative bodies are accustomed to applying indirectly, because this is a principle, this is a concept. And we cannot just say that we know rule of law when we just see it. For the EU to become a community of values, we need standards. We believe that setting these standards is not legal or administrative process, but based on our very experience, a merely highly political one, where member states need to be deeply involved. Also through their constitutional bodies that interpret and uphold rule of law in the domestic context. As also Mr. President just referred to, that the domestic context is key. We believe that member states should set such standards for EU institutions as well. And in turn, the institutions should establish instruments to ensure compliance with those requirements from their side. And I was happy to listen to Vice President Jourova's speech when she actually also said that we institutions like the European Commission, European Parliament and the Council, they also share respect their own rules. This is also rule of law. M from smog, S-M. M stands for methodology. The EU now has not only rule of law reporting, but also rule of law sanctioning mechanisms at its disposal. A strict methodology is required to identify breaches and the feasibility of launching certain procedures, as well as the necessity and proportionality of particular measures. All this in a strictly objective and neutral way that treats, and here comes the very important part, comparable situations in a comparable way, irrespective of the fact, for example, whether the mainstream media is constantly reporting about a member state or whether the mainstream media is not constantly reporting about a member state. So, to comparable situations in comparable way, and this would provide enforceable guarantees through meaningful legal remedies. And peer review processes used in international institutions like the OECD for quite some time now for a valuable experience in this regard that we have failed to take into account until now. I do recall Commissioner Reynders was member of the GAC as a minister back in 2019, and there was a very, very good proposal from Belgium and Germany coming up with this kind of intergovernmental, non-biased, non-partisan approach, the fair treatment of all member states peer review proposal. Unfortunately, it was taken off the table, but we should maybe recall this kind of exercise. O from the smoke stands for ownership. Rule of law mechanisms work only if the institutions and member states involved look at it as something being done for them, with them, and also done to them, not against them. Otherwise, instead of reinforcing unity and rallying member states behind our shared values, they will only create divisions and mutual distrust. Solid standards and methodology goes a long way in creating political ownership, but the culture of consensus also needs to be discovered again. The culture of consensus, which is the basis of the European cooperation. And finally, G stands for governance. As the presidency of the Council, Hungary will seek to reinstate the Council as the center of rule of law related procedures. When we speak about peer review, this is exactly what we mean. And when we speak about Council decisions in other procedures, we mean a decision in Council based on a number of resources, genuine political debates, and independent analysis. So these initiatives are closely connected to the review processes and activities planned by the previous presidencies, and we are committed to working closely with them and build them on their achievements. And finally, ladies and gentlemen, we often hear in European Union corridors, where there is a will, there is a way. We often hear this, but let's make no mistake. This is exactly the opposite of rule of law. For the EU, rule of law means respecting the limits of competencies, applying the principle of legality, subsidiarity and proportionality, as well as the obligation of the EU institutions to respect the national identities of the member states, including their constitutional, legal and cultural heritage. There are limits to what EU institutions may do as regards rule of law. And this is not a defeat for rule of law. This is exactly its application. So, ladies and gentlemen, I'm available for your questions because Hungary was so often mentioned, and I'm happy to be with you here. Thank you very much.
Thank you so much, Minister Varga, and I also want to say thanks to all the panelists for abiding by the only rule of law requirement here, that is to keep time. And you did that collectively well. Now, I'm now looking into the audience in the room for questions, and I will pick a few, I'll notice, but before that I would like to turn back perhaps to Commissioner Reynders, if when listening to the presidency now and the future trio, from your perspective, is there something in particular you would like to pick up? And then I will open.
First of all, I want to say that what is important is to continue to work on the rule of law in the Council, because there are many discussions in the European Parliament, there are a lot of discussions in the Commission. I've seen more and more rulings from the two courts, not only the European Court of Justice, but also the European Court of Human Rights, and it was more difficult to have debates in the Council. It's quite logical between the member states, but now it's a real tradition. I've listened, in the next presidency it will be every month that we will have a discussion in the Council. That's very clear. Also at the level of the European Council, it's very important to see that also at the level of the leaders, there are now discussions about that. And I want to insist on 2 points. The first one is that all the procedures that we are organizing are going to the Council to be concrete. If you have an Article 7 procedure, is to discuss in the Council. If we discuss due to the specific situation that we have had about the recovery and resilience plan, at the end is to ask to the Council to approve a plan and with a negotiation with the different member states. And when we ask for the conditionality regulation application, it's also at the end of the Council that the discussion is coming with specific rules with qualified majority. The report of the Commission that I'm very proud to publish every year since 2020 is just a report of the Commission with recommendations, no more than that. And of course, we engage in discussion on such a basis with all the possible actors. And it's just when it's needed that we are going to the Court of Justice. Because of what? Because if there's a need to give an interpretation to the EU law and to explain what is it, to give an example, independence of the judiciary, we need to go to the court if we are in conflict with one member state, because we are thinking that there is a regression, I said. Because we don't ask to have the same justice system in all the member states. We don't ask to have the same mechanism in all the member states. We are said by the President of the Court, we don't have constitutional court in all the member states. You know that in Sweden. But we ask to be sure that we have an independent justice system. And the comment that I want to make to conclude is that I'm very open in the future, if it's possible, with the next presidencies, not only to exchange about the situation in all the member states, but also to discuss about what that means, the independence of the judiciary, to be very concrete. The first issue that we discuss is the appointment of the judges. What is the best solution to organize the appointment of the judge in the member states? If you look to the member state where the intention is to create a judicial council, we have a reference in the Council of Europe saying that such a judicial council must be composed by a majority of judges elected by their peers. But it was a discussion among the member states of the Council of Europe. So I will be very pleased after the exercise that we are doing now, maybe to engage a real discussion about what are the best ways to implement the rule of law and to describe what that means, independence of the judiciary. Without that, we have more and more rulings of the Court of Justice explaining what is the interpretation of the Court of Justice. But it's also possible for the member states to discuss about that in certain limits, of course.
Thank you so much, Mr. Commissioner. Now we have one question over there, and if you could please state your name and affiliation. And then...
Me?
Yes, for you, Susanne.
My name is Susanne Palmer from the Swedish Radio. I would like to ask the next trio of countries holding the presidency, Hungary, which is found to be in breach of the rule of law. Do you think Hungary will be fit to lead the discussions of rule of law and the dialogue and also Article 7 procedures in the Council? Or how can you solve this? Could some other countries, some other of you lead these discussions maybe? Or how is it a problem for you that a country which is in breach of the rule of law is conducting these, leading these discussions? And then another question for Mr. Reinders. The conditionality principle has been used now against two countries, Hungary and Poland, and funds have been withheld, but still they are not fulfilling the requirements of the Commission. So how effective is this instrument, do you think, to have these countries comply?
Thank you so much. Two difficult questions. Well, let's start with the first one about the presidency. If I may turn to you, Mr. Navarro, to begin with this.
I am the I am the destinatory.
You can have a chance.
We are discussing here the work of the Council. The presidency of the Council works for the Council, and the Council has its own rules how to conduct their debates. It's very clear the role of the presidency in conducting those debates. So everything has been foreseen as any possibility, and as I said, there are some rules about that. So there have been cases, for example, in a certain discussion that if a certain presidency considers that they cannot or they are not in a position to do it, or because it's ill or something like that, it gives the floor to the following presidency to conduct a particular debate. Well, that had happened. But it's not, nothing is written about that, so I mean, nothing is decided about that beforehand. So there is, the Council has its own rules. It's in the regulation for the Council. It's a regulation of that, and the conduct of the presidency is very well foreseen. But so there are different possibilities, but I don't see any difficulty, any particular difficulty in what you said. That's any of us can conduct the discussion, and the Hungarian presidency, I get that they can conduct the different discussions in the Council. I don't have any.
Thank you, Ambassador De Taille or Minister Varga. Do you want to add something on this?
Yes. Well, I'm not a politician, so I'm not going to do any political statements here. But for us, our position is that anything that would be discussed in that has to be an agreement within the trio. That's what I wanted to add. Thanks.
Minister Varga.
And thank you very much for the question. Actually, we started the trio cooperation already 1 year ago, and we identified the rule of law discussions among the trio priorities. It is also under the in future published trio program. So there's no question that Hungary is putting this on the agenda, as I also said in my introduction. And let me also just correct your question, because it was rather a statement that a country which is in breach of rule of law. I just would like to remind you that Article 7 procedure is there, but there's a presumed danger to the breach of rule of law. It is not stated yet, so please don't deny of us the presumption of innocence. This is a very important thing when we are discussing rule of law. We cannot empty those values which we are there to defend here in this discussion. And Hungary has already proved to be a very efficient and honest broker during our first presidency in 2011. And this is a unique opportunity also for Europe, that now there will be the same government actually holding the European Union presidency who had back in 2011, so it will be 13.5 years ago. It means a unique political and administrative stability and continuity in EU presidencies, because there will be the same Prime Minister, the same government, and some ministers, like Minister Navracsics, former commissioner, or the Internal Minister, they are still the same ministers who were ministers back in 2011. I think this is a genuine opportunity to show best practices for other member states as well. And of course, we will always be able to manage all those issues which are of European interest. And we have a lot of experience about rule of law proceedings in a non-biased and a fair trial approach. Thank you very much.
Thank you, Minister Varga. Commissioner Reinders, you got one question directed to you on the conditionality.
First of all, I want to say that I share the last comment of Judith Varga, because I have myself had the opportunity to share the ECOFIN in 2001 and in 2010. So if you have an experience, it's maybe useful to do that. No, but more about the question concerning conditionality. First of all, concerning conditionality, we have only a decision about Hungary, not about Poland. Poland and Hungary is for the recovery and resilience plan, not for all the member states. And I want me to make two remarks. The first one, on the recovery and resilience plan, it's for all the member states that we have some requests for reforms, and we have seen in different member states that without the real reforms, it's impossible for the Commission to agree on a possible payment of the different resources provided by the plans. It's not only with 2 member states, it's for a lot of member states that we have such a discussion. It must be very clear. So it's an equal treatment on all the member states. About the conditionality is something else, so it's only about Hungary, and we have a lot of milestones in the recovery plan, but also in the conditionality for Hungary. And what I've seen is that there is efficiency of the 2 mechanisms, but certainly also the conditionality. Why? It's the first time that I've seen such a real opportunity to discuss reforms, but not only to have a discussion, to see some proposals of draft laws to try to implement the reforms. I have seen, to be concrete, in the recovery and resilience plan of Poland that it was possible to go to the parliament with a draft law to try to implement the different reforms about the judiciary. It's blocked before the Constitutional Tribunal for other reasons. I want to detail that, but the willingness was there, and I've said with the Mr. Varga, with Judith Varga, we have had a long discussion about the milestones and then about the implementation, and now there's a law into force since the 1st of June, and I've said myself, it's a real improvement. So we have seen, of course we are not at the end. There are a lot of other reforms that we need to do, but it's not true that it's inefficient. We have a real efficiency, and we have seen a real intention to come with some reforms. Of course, we are not at the end of the process.
Thank you so much, Commissioner. We have a question from here, and then one in the far back, and we will take them, both of them at once. So, yes, please.
Thank you. David Vig is my name. I'm from Amnesty International working in Hungary. We have heard from Commissioner Reinders and also Minister Oswald that there has been a change introduced in Hungary with regards to the judiciary just a few weeks ago. I would like to ask Minister Varga whether she can name one or two provisions for which she is really proud of, where Hungary has managed to fix a rule of law problem from June 1st. And my second question is that is also relates to this process. The Minister of Justice in Hungary met civil society one single time during this conversation, which is a welcome development after 6 years of silence. I was wondering whether Minister Varga found it beneficial for the process, and if yes, whether she can commit to further meetings as we go forward. Thank you.
Thank you so much for also pointing the questions, directing them and being relatively short. And then in the very far back, we have one more question, and then I will hand over to you, Minister Varga.
Yes, thank you. My name is Sophie Infeld, member of the European Parliament. Now, the Council, of course, freely decides on its own presidency. That is none of the business of the European Parliament. However, we are the other legislator. And you may have noticed that the European Parliament has adopted a resolution a few weeks ago, let's say, highlighting its concerns over the Hungarian presidency. You will have to work together with the European Parliament as well. Now, how do you see that if the European Parliament doesn't actually, as you said, Mrs. Varga, consider that there may be a risk for the rule of law in Hungary? We consider that it's a kleptocrat regime which has attacked the judicial independence, the independence of the media, the independence of academia, which is constantly abusing its veto to hold the entire European Union hostage, blocking sanctions against Russia while you're making deals with Russia. Now, you will have to work with the European Parliament as well. The Parliament has expressed deep distrust against the Hungarian presidency. I would like to know, also from the trio, how you envisage working together with the other legislator. Thank you.
Thank you so much. And I think all questions here were directed towards Minister Varga, so therefore I hope you took notes, and I give you the floor.
Thank you very much. My last question, actually, from the honourable member was directed to the whole trio, so sure. That's me. Well, thank you very much for the question from Transparency International. I'm afraid that the time frame of this symposium would not be enough to tell the story of the judicial package, what we just agreed with Commissioner Reinders. But I personally, what I think it's a great achievement that after so many political statements and allegations in the press and elsewhere, we managed, based on a respectful dialogue with the Commission, to put this form of concerns into a real professional dialogue, and we managed to find and identify certain elements of the law where there could be improvements based on external requests actually from the Commission, and this was actually translated into the existing and effective functioning of the judiciary. But here I have to make clear one thing, make one thing very, very clear. Under the Hungarian judicial administration system, there is no, by any means, any kind of non-constitutional, non-personal, any relationship between the executive and the judiciary. It is a model in Europe which is quite unique. Not every member state can have this, as was said, that every country is different with traditions, where the executive is completely detached from the judiciary. It also means that when it comes to election of court presidents, county courts, or appointments of judges, it is in the hands of the judicial councils, the judicial colleges, and their own internal democracy, let's say. And reform, I wouldn't call it a reform, because the reform needs, I think, a bottom-up approach, and this was actually in the framework of the negotiation of the horizontal labeling criteria, which is a budgetary issue, an MFF issue. However, the package actually will affect now the internal power balance within the Hungarian judiciary, not between the government and the judiciary, because this kind of relationship does not exist, nor constitutionally nor politically. This is a judicial system in Hungary, where there were already, before the package, power centers like National Judicial Council or National Office for the Judiciary, and thus power balances might change thanks to certain amendments in the powers, especially in the hands of the National Judicial Council. So this is one thing which I would just highlight, because we managed to talk about real issues after so many, the overall picture, judicial independence. But if you look into the merit of the case, and if you went back to your own country and would check what is now required from Hungary, whether you would be able to introduce all those steps in your own legislation, in your own judicial systems. So this is also key here, to have a comparative law analysis and to avoid any double standard. I do hope that the law, which is already in effect since the 1st of June, will have a very good and tolerant reception among judges, because, and here I can come to your second question, the point is when we are affecting the everyday life of 3,000 judges in Hungary, as a minister being responsible for the well-being of the Hungarians, among them also the judges, what is my responsibility? To pay attention to the opinion and legal opinion of the international network of NGOs, or the opinion of the judges themselves. I mean the trade unions of the judges associations, and those persons who are affected, because I think democracy is about asking those persons who will be actually affected by the law being drafted themselves. And here there was, during the consultations, a clear conflict of opinions between the big international NGO networks' opinion and that of actually the individual judges and those who will be affected in their everyday personal life. And as a humble minister, being elected by the Hungarian people, I'm also actually a member of the Hungarian Parliament and Assembly, my responsibility, my primary responsibility, is therefore my judges' opinion to be respected during the negotiations. And I think we managed to find a quite good balance between those opinions. But here is actually a European value at risk, democracy. Democracy is about the people, and about those judges who are now being affected. And it's not about NGOs and foreign-funded international NGOs. This is very important to say, especially for the Transparency International. And I'm sorry for the political statements of Sophie Inwelt. I can only say that European elections is on the way, and I will do my best to help the conservative movement in Europe to have majority next summer in the European Parliament. Thank you very much.
Thank you. We are running a little bit out of time, but I want to make sure that although there is room for the other panelists, there was a broader question about the sort of relationship to the European Parliament, if you want to add, and then perhaps something from Minister Roosevelt to conclude. State Secretary Navarro.
Yeah, there was a question about the trio. As I said, for the conducting of the presidency, there are some rules in the regulation of the council. If a chair is not in a position to conduct the debates, because usually it's because of illness, so it asks the following presidency to take the chair. That has happened, and I've seen it in some, even in Spanish presidencies before. Different is the question of the trio. The trio is a common program for conducting the work of the council during a certain moment. It's particularly important in this moment of changing of the institutions, and we have prepared this program considering this situation. We will present it, Jessica, next week. And the trio foresees, as you said, by consensus, some arrangements. For example, Hungary has asked Spain to chair fisheries groups, of course. We have agreed, for example, with Belgium will chair internal market groups, for example. But beyond that, we haven't agreed anything else. That is the kind of arrangement usually foreseen in the trio. So nothing beyond that.
Thank you. Do you want to add something very short then, please?
That in the trio program as we have, there is a quite strong passage on a paragraph on rule of law, as you might have seen.
Then we're eager to see once that is presented. Now, Jessica Roswall, Minister for EU Affairs in Sweden, you're now coming to the very end of the presidency. So what would be your main takeaways or messages that you want to?
The takeaway from this panel is that the rule of law will be in top agenda on the common presidencies, which is a very good to know. And I'm looking forward to that. And I'm handing over the torch to you, Pascual. I will be very short because in Sweden we have things called fika. It's very important. It's coffee and something sweet, and we have to go for that. This is timely to have this discussion on this symposium and see what the tools we have. Do we use them correctly? Can we make them more effectively? And also to continue this torch to the presidents to come. So this was a really interesting panel. So I'm very happy that you all came, and of course you did, and we'll see. And thank you to the European Parliament. We have had a good collaboration during this 6 months.
Thank you so much, Minister Roswall, and thanks to all the panelists. It was great and highly stimulating, and let's give them a round of applause. As the minister said, having coffee and something sweet is called fika. It's a very important word to know, and it will be served outside, and we reconvene no later than in 20 minutes from now. So please make sure to come back. Thank you. Ladies and gentlemen, welcome back. Could you please take your seats? I hope you enjoyed the coffee break, and I can hear that there are some stimulating discussions. Now we are going to move on with our panel, which we have panel B, under the title, How is our union doing? Providing different perspectives. And so far we talked quite a bit from a EU institution perspective, but now we will also add a variety of different perspectives and voices to assess the state in which we are in. And the following panels today and for tomorrow, there are also discussion papers or briefings that you find in the folder that are sort of framing a little bit the discussion that we are going to hold together here. Now, with me, I have a great panel that I will introduce. Ms. Herdis Storgeisdotter is Vice President of the Venice Commission at the Council of Europe. Mr. Laurentio Pluciano is the Vice President of the European Economic and Social Committee. Ms. Elsa Pilishovsky is the Director for Public Governance Organizations for the Organization for Economic and Cooperation and Development, that is the OECD, that we normally know when we don't stumble on the words like that. Ms. Renate Schröder is the Director of European Federation of Journalists. And last but not least, Henrik Blomqvist is the Deputy Secretary General and Director of Policy for the ICC, Sweden, the International Chamber of Commerce. And we will now listen to some introductory reflections from all the panelists in the order in which they stand, after which we again invite for contributions and comments, reflections and questions from all of you. Now, our first panelist to start is the Vice President of the Venice Commission, as I said, and the Venice Commission provides legal advice and assists states in bringing their legal and institutional structures into line with the European standards and international experience in the fields of democracy, human rights, and the rule of law.
Thank you very much, Mr. Foncito. It's a pleasure to be here, honor. And ladies and gentlemen, I will be speaking on behalf of the Venice Commission and the Council of Europe. The rule of law, as you know, is one of the three pillars underlying all the work of the Council of Europe: rule of law, democracy, and human rights. The rule of law, which you've heard probably for the 10th time today, means that everyone has the right to be treated by all decision makers with dignity, equality, rationality, and in accordance with the laws, and to have the opportunity to challenge decisions before an independent and impartial court through fair procedures. Impartiality of the judiciary must be ensured in practice as well as in the law. The classical formula is that justice must not only be done, it must be seen to be done. And as we are here tackling the issue of a reality check on the rule of law, I thought it might be best to tell you about an interesting opinion of the Venice Commission adopted in 2019. It was requested in 2018 by the Parliamentary Assembly of the Council of Europe in the wake of a report on the assassination of a journalist, Daphne Caruana Galizia, in October 2017, and the rule of law in Malta. As the report ended, ensuring that the whole truth emerges, a case which attracted attention over all of Europe and beyond. This Venice Commission opinion elucidates the interrelationship between the rule of law, democracy, human rights, separation of powers, right to life, journalistic freedoms, corruption, and abuse of powers. This journalist, Daphne Caruana Galizia, was assassinated on 16th October 2017. As a journalist and a blogger active for 30 years, she had reported on politics in Malta, focusing on government corruption, nepotism, allegations of money laundering, probably knowing that she had put herself in danger, although not foreseeing that someone would place a bomb in her car which exploded and killed her instantly. The alleged ineffectiveness of the investigation to find any person who ordered this assassination and the alleged culture of impunity in Malta had been criticized. The scope of the Venice Commission opinion was confined to the constitutional arrangements in Malta, where the economy was thriving, but also at the time perceived as fostering widespread corruption. The Panama Papers a few years before had exposed more than 200,000 tax havens involving high-profile people, government officials, and entities from over 200 nations, revealing corruption affecting all the member states of the Council of Europe and also showing corruption in many of the EU member states which was costing the EU economy around 120 billion euros per year, and some say even as high as 990 billion euros. But the higher cost is the ruined lives, the erosion of the rule of law, and the decay of democracy. In the last 10 years, 28 journalists that have investigated corruption have been killed on European soil. Journalists, as the Venice Commission emphasizes, have special duties. They have more duties than ordinary citizens. Hence, they need special protection. The Venice Commission insisted in this case on the positive obligations that every member state, all the 46, at the time 47 member states of the Council of Europe, have towards their citizens, everyone within their jurisdiction, to guarantee to all of them, under Article 1 of the Convention, the rights in the Convention to all of those in their jurisdiction, to guarantee their right to life, and to guarantee their right to freedom of expression. And of utmost importance in this case was examining the possible connection between the assassination of the journalist and her work covering corruption. The Venice Commission also emphasized in this opinion the need for preventive and repressive measures which are required to fight corruption. While the Minister of Justice in Malta told the rapporteurs, and I was one of them, that they had come up with various reforms, legal reforms, such as an act on whistleblowers, an act on defamation, an act on political party financing, and various other laws to tackle corruption. The Venice Commission emphasized that, as with any reform, it's obvious that not only the legal text matters, but also the implementation in good faith. The opinion criticized the double role of the Attorney General as advisor of the government and prosecutor, the part-time Parliament found to be weak to exercise sufficient control over the executive branch, the Prime Minister's wide powers of appointments, the President's and the Prime Minister's appointments of judges, creating a serious risk for the rule of law. This problem was reinforced by the weakness in Maltese society at the time, where people were censoring themselves and the media was extremely weak. The Venice Commission emphasized that even though it's difficult for authorities to endure harsh criticism, they had to bear with it, because this is the role of the media, to be the public watchdog. The list of recommendations, I'm finished in half a minute, concerning the judiciary, the public prosecutor, Parliament, the need to involve citizens in amending the Constitution, and finally, for the authorities to adhere to the role of the media as public watchdog, to ensure that there is a robust political debate in the country, to create what the Venice Commission calls an enabling environment that fosters the rule of law and democracy and human rights. Thank you very much.
Thank you so much, Ms. Torgesdotter. We will move straight on to our next panelist, Mr. Prusianu, who is the Vice President of the European Economic and Social Committee floor is yours.
Thank you so much, distinguished audience. First of all, let me express my appreciation for the invitation to take part in this distinguished panel. We refer to the European Economic and Social Committee as a house of the organized civil society, which means that we gather employers, workers, and representatives of civil society organizations in a wide variety of sectors. The EU treaties grant the ESC a formal say on EU legislation as a consultative body, and we can also express our views through own initiative opinions. This has allowed us to develop a good corpus of opinions in the area of fundamental rights, democracy, media freedom, equality, and of course the rule of law. The ESC has a specific approach to these domains, which is complementary to the one of the other EU institutions. We listen to civil society actors about trends in this area, and we create spaces for discussion. Building on our membership and networks among social partners, we also bring a particular socio-economic angle to developments in these areas, meaning that we do not undertake deep legal assessments of specific situations, but we rather focus on their implications for civil society actors. We notably do so through our dedicated fundamental rights and rule of law group, which has been visiting all EU member states to take the temperature of what is going on in our continent based on discussions with a total of more than 600 representatives from civil society, notably social partners, civil society organizations, the media, and legal professions. These reports that the group produces represent a building block for constructive dialogue between authorities and civil society. So, how is our union doing? That is a question that I cannot answer in 3 minutes. What I can tell you, based on what we have learned from our country visits and other interaction, is that, firstly, the depth of challenges varies a lot from one member state to another, but no member state is devoid of challenges. Secondly, generally speaking, civil society faces a multitude of constraints and pressures that make their essential daily work more difficult. And thirdly, a positive note that is that we see that civil society, including social partners, show a lot of resilience and determination in the defense of the EU's founding values. Civil society is certainly part of the solution, and it is striking to see that demands for greater involvement in decision-making are general. The right to participation in public affairs is a central enabler for a healthy civic space and the better defense of all rights and the rule of law. Our committee is working in that direction. Thank you very much indeed, and I'm looking forward for the discussions.
Thank you so much, Mr. Prusiano, and I'm sure we'll get back to some of these issues, particularly on civil society. Moving straight on to the OECD and Ms. Pilichowski.
Very well, thank you, and thank you very much for this invitation and these great discussions this afternoon. Maybe I would like to take a little bit of a step back and going back to the term reality check and think about one issue first. Is it that there is a decreasing sentiment in favor of democratic governance that creates situations in which the rule of law can be weakened, or is it a weakening of the rule of law that's actually undermining democracy? And of course it's a chicken and egg dilemma, but it's a very important chicken and egg to know where to actually take action, on which fields to take action. So this was the starting basis at the OECD of what we call the Reinforcing Democracy Initiative that was started after the events on Capitol Hill in January 2 years and some months ago. And of course, as you know, the OECD is 38 countries, including 22 EU countries, so the EU is very well represented, but it's also wider, going to the US, Canada, and also some countries in Asia and in Latin America. And we started with the idea that we had two types of scissor effects at the same time in the world. The first one was that, on the one hand, democracies have been very resilient and delivering very well for their citizens compared to autocracies in the last decades, but also very much since COVID. And at the same time, we're seeing a backsliding of democracies in the world. So that's the first kind of scissor effect. Then there's a second scissor effect, which is that citizens are asking more and more in our democracies from their government, and at the same time their trust in government is relatively low. So we started with these two scissor effects, trying to understand what was happening. Starting from there, we started to work on the drivers of trust in institutions. And last year we did a big exercise with 22 countries, and which gave us some answers to that. And a few of those answers are as follows. There's, in terms of the drivers of trust, the quality of public services, the fact that governments are delivering well during COVID, etc., is quite high as a driver, but the level of satisfaction in our countries is relatively high. So the room for maneuver for increasing trust is relatively small. Where we have a lot of room for maneuver in terms of increasing trust of citizens in our institutions is on representation and participation, and also responsiveness of governments to society's needs, but that also includes very much something about how to respond to justice needs, how to make sure that we have people-centered justice systems. And also the second aspect on which we can do a lot of progress is on perceptions of integrity. Whether these perceptions are related to reality or not is a different issue, but we have an enormous amount of people in the OECD countries, including in our most advanced and sophisticated societies, that believe that their society is corrupt, and we have many, many indicators on that. So these are things on which we know that we can act. Starting from there, we define with the 38 countries which would be priorities for the future, and we had 5. One is the fight against mis and disinformation, very complicating. We can talk about that more at length. Another one is representation and participation, and also people-centered justice as part of that. Another one is fighting foreign influence, and the last one is green democracy and also digital democracy. That is about how to uphold the rule of law in the digital world, where it's a space in which we have been, to a certain extent, failing our citizens so far. And we tend to underestimate that. So these are the priorities. Just one more word, and then I leave the floor to my colleagues here. We will be publishing on the 30th of June our big thing, which is called Government at a Glance, that will be looking exactly at that, at democratic resilience, how to build on the strength of democracies. This is about citizens' participation and representation, how to fight the threats, especially on foreign influence, including on mis and disinformation, and how to build capacity for more resilience in times of crisis, which we think are big drivers of trust in the future. Thank you.
Excellent. Thank you so much, Ms. Piliszowski. That was very interesting, and things that we'll come back to for sure in the discussion. Now over to you, Ms. Renate Schröder. You are the director at the European Federation of Journalists.
Yes, thank you very much. Thank you, Chair, and thank all of you for your presentation so far. Thank you to the audience to still listen. It's a pity we don't have the ministers and commissioners here anymore, but however, I'm motivated to tell you just a little bit about the state of play regarding media freedom. Just shortly, the European Federation of Journalists is a federation of journalist unions and associations. Our members are in all EU and Council of Europe member states, plus Belarus, plus Russia, both of them in exile. How is our union doing? Indeed, we heard a lot already, and I guess all in all still rather well, but as we heard today, there are many reasons to raise the alarm bells and not to be complacent when it comes to protecting media freedom. The EFJ has been monitoring with its partner organizations serious violations of media freedom throughout Europe. According to a report published by the Media Freedom Rapid Response Mechanism, which is supported by the European Commission, there have been 415 recorded media freedom violations in EU member states. So you can imagine in reality there are many more. Those include verbal attacks, harassment, threats, legal incidents, physical assaults. Fortunately, in the EU, no killed journalist last year, but I thank for referring to Daphne and other journalists who were killed. Last year's European annual report on the rule of law highlighted several threats to media freedom. 16 member states have been urged to take measures to protect journalists, media freedom and pluralism, including on the need to safeguard the governance and editorial independence of public service media, the need on more transparency regarding state advertisement, and also the urgent need to tackle the use of abusive lawsuits to silence journalists. In Brussels, we all hear SLAPs. You may not have heard about it. These are strategic lawsuits against not only journalists, but human rights defenders, civil societies, you name them. A growing concern indeed within the journalist community. We had 39 cases of SLAPs recorded last year, so 39 times serious attempts to silence journalists, often targeting those working in the public interest, be it on corruption, on human rights, on other issues, you name them, relevant, I'm sure, all to the rule of law. I just give you, as we have little time, 2 recommendations, and I'm happy to give you many more regarding the rule of law mechanism and how to make it more efficient in the future when it comes to media freedom. So one, and I think very important, it's to increase the visibility and awareness among affected journalists in member states to build trust. We heard how trust is important and how much problems we have these days with trust, specifically at local level, in the effectiveness on the rule of law process, not only in a hotel in Stockholm, but throughout our member states. Second, pressure the EU Council. We had a nice discussion with the upcoming tripartite council people to regularly and publicly debate and draw attention to effective measures taken by member states regarding media freedom, but also to apply pressure on those states that continuously harm media freedom. The EFJ has appreciated the pivotal efforts by the European Commission on the work for the Anti-SLAPP Directive, but also on the European Media Freedom Act we heard earlier today by Vera Jourova. But, and here I'm coming to my very unfortunately, and allow to express some frustration, these 2 very important legislative acts are being diluted and reflect the lack of strong political will, at least in the Council, to act in favor of freedom of expression. The Council position on SLAPs is far too restrictive to have a meaningful impact. If it is, in the end, adopted as it stands, it would cover about 2% of SLAP cases. The latest coup regarding the draft Media Freedom Act, actually, it was said today, the Coreper adopted a text which includes, for us, very serious and dangerous amendment regarding the protection of sources, regarding surveillance from spyware, from any surveillance technologies, and that is an exemption on national security, which was introduced by France. This potentially opens the door to many member states putting national security above media freedom. And we believe this indeed is exactly the opposite we want from a European Media Freedom Act. In our view, the journalism is a public good, media freedom and pluralism is a very important antidote to disinformation and thus also to national security. And we are very concerned right now that this decision will again decrease the trust journalists have in EU institutions, journalists have in the efforts to have a European Media Freedom Act at European level. Thank you very much.
Thank you so much, Ms. Schröder, for that. And last but certainly not least, Henrik Blomqvist from the ICC. The floor is yours.
Well, thank you for the kind introduction. It's an absolute pleasure to be here today to discuss why this topic is so relevant to the business community with you. The ICC, the International Chamber of Commerce, is the world's largest business organization. We represent 45 million businesses in more than 170 different countries. And ever since our founding in 1919, in the wake of the First World War, it has been our core mission to promote peace and stability for economic integration integration, to ensure a rule-based system for international trade, and to promote responsible business conduct. Through our own International Court of Arbitration, we also ensure that companies have access to justice whenever commercial disputes arise. So it's fair to say that this is a subject that's close to our hearts. But why is democracy and the rule of law so important for the business community? Well, it boils down to stability and predictability and the conditions of certainty under which businesses thrive. And there are three main aspects of this. One, democracy and the rule of law ensures recognition and protection of private property, so that businesses can be certain that their tangible as well as intangible assets enjoy protection from infringements and from nationalization. Two, it ensures that businesses have access to justice whenever contractual obligations are not met and when disputes arise. This also means that arbitral awards, such as those awarded by the ICC court, are actually enforceable. And last but not least, democracy and the rule of law safeguard fair competition and a level playing field between companies. And it mitigates corruption risks so that bribes and undue influence do not decide who gets the client or who wins the public tender. And these are all key for a good business environment, for innovation to flourish and to attract investments. And it is fair to say that the EU is among the best in the world in all these regards. But of course we have to make sure that we stay that way, and we have to address the very serious concerns that have been raised by the panelists today and in previous panel. Because deficiencies in democracy and the rule of the law, on the other hand, creates risks and uncertainties that are detrimental to businesses, that drive up operating costs and scare away investors. And if I could just make one final point. If we consider the huge investments that will be needed in the coming decades for the green transition, and regarding the increasing uncertainty in the world in terms of geopolitical tensions and financial instability, then the importance of democracy and the rule of law becomes ever more pronounced. Because without the stability and predictability that they offer, the world would be a much more uncertain place for businesses to operate and for investors to make big long-term investments in. And with that, I'll hand back to the moderator.
Thank you so much. Thank you so much, Mr. Blomqvist, for that very short and concise introduction. Now, to my mind, there are various questions that arise, and you all present perhaps slightly differing perspectives. But we're now going to have some exchange of views. But as I've said all along this day, I strongly encourage you to engage, to ask questions or reflections, comments from the audience. And we have one in the very back, so please just introduce yourself and you will have a microphone there. Yes, thank you.
Yeah, hello, thank you very much. My name is Christian Moos. I'm a member of the European Economic and Social Committee and rapporteur for the European Media Freedom Act and also for the Commission initiative on the strategic lawsuits against public participation. And I would like to ask in particular Renate Schröder, hello Renate, whether she believes that this very frustrating, disappointing state of play as regards the member states' efforts to defend media freedom, to really defend media freedom. I mean, everybody's talking about democratic resilience and the rule of law and how important it is. But if that is the state of play, and that being a very important, a carrying pillar of rule of law and democracy and liberal democracy, what does that mean with a view to the previous panel and Mrs. Varga being very confident that her understanding of democracy and the rule of law will ultimately prevail? Have we woken up? Thank you.
Thank you so much. I think we direct that to Ms. Schröder. In the meantime, please wave so I can see your hands, Ms. Schröder.
Yeah, thank you very much for this very good question, which shows that it's all connected. And indeed, I have also wondering when I listened to the panel before, specifically the minister from Hungary, that there is a lot of double speech out there. There is a lot of lip servicing. We all use the same words, but we all mean different. We all have different interpretations. And of course, it's never easy, specifically when you deal with 27 member states from very different backgrounds regarding, and you know it, the Media Freedom Act it has been, and I've been working almost 100% on that, it has been extremely difficult because media so far has been something dealt with at national level, very sensitive issue. There has been the Audiovisual Media Service Directive, but the Commission once 30 years ago tried to have a green paper on media concentration. It failed. In the end, it failed because there were some media moguls, Rupert Murdoch at the time, Leo Kirch and Berlusconi, I can assure you, who in the end boycotted it. And now we have a new effort by Vera Jourova and this commission, and we are very thankful for that. For us, it's politically speaking extremely important, but now we see on the side of member states, I gave the example, national security being more important than protection of journalist sources, but also on the side of particularly big publishing groups who want to have, they say they have the employers, the companies' rights is on their side. They are the ones who defend press freedom, not the journalists. They want to keep the editorial control. So we are fighting on many levels. We very much rely now on the European Parliament, and I'm very happy that we have Sophie and Field here as a representative to help us in the trilogue meetings, but even there it is not easy, and sometimes I want to give up, but I owe it to all the great journalists I have the pleasure to work for, who are sometimes working against all odds. I really wonder, because their work is dangerous, their work is precarious, and yet they still, many of them have this vocation to be a watchdog, so much needed in today's society.
Thank you so much. For the rest of the panelists, you either wave to me if you're desperate to jump in, or we come back. So I don't see any desperate waving. There is one more question down the bottom line.
Hello, my name is Vidar Andersson. I'm a political editor at the local newspaper here in Sweden. I want to address Elsa and your very interesting presentation. I wonder, do you have an answer on your chicken and egg question? I didn't hear if you really had an answer. Is it the weakening of rule and law, or is it the weakening of democracy that is our main problem? Do you have an answer?
Listen, it's a very difficult question. That said, I'm taking what our governors have been doing, and which also align with what I think, which is nice. I do think there is an issue now with larger groups of our populations that are dissociating themselves from traditional democratic processes, and I think we can all recognize it in all countries, in all advanced countries. Not only, it's not democratic backsliding in certain countries that are becoming more autocratic, it's also groups of our societies that are distancing themselves. It shows in different ways, in different countries. Culturally, it evolves in different ways. So I do think this is happening, and this is much beyond the rule of law issue, and it does have major consequences because it lays the ground for some governments or some institutions to infringe on the rule of law. So if I had to take a stand, I would say obviously we have to defend the rule of law as much as we can, but if we don't address the underlying factors that have to do with this dissociation, then we're fighting the wrong fight, if you want. So it's those factors that have to be taken into account. That said, the solutions for that are very difficult, and also they are about renewing the way we think about our own democratic governance. Thinking of journalism right now, as we were talking about journalism and the need to protect journalists, there is no doubt today that we are at that moment where we absolutely need to defend the media, support the media, and there is a need for government intervention in that field, also in the field of mis and disinformation, but at the same time, in our traditional democratic systems, they have been made so that governments remain as far as possible from that. So governments are in an incredibly difficult situation where in our democracies, democratic governance implies that the governments are at distance from the information that is published by journalists, and at the same time today we know that there needs to be government intervention not on saying what is true or what is not true, but in supporting the system for information integrity. And that's a big democratic questioning that we haven't solved yet. It's about new partnerships with the media, but we need to find a new governance for that.
Thank you so much, Mr. Dushovsky. I will soon get back with a general concluding question to all of you, but one area where I would like to stop a little bit is this more, let's say, the economic side of it. And you raised it yourself, Mr. Blomqvist, and it was also touched upon earlier. In the EU context, we often talk about the internal market, and for the internal market to function, you need a proper, also functioning system of the rule of law. But I think both at the OECD and I guess also stemming from your presentation, Mr. Blomqvist, you have some concerns about sort of how does then how does erosion of rule of law affect competitiveness and the functioning of the internal market? So maybe if the two of you would like to elaborate a little bit on that. Do you want to start, Mr. Blomqvist?
Sure. But I also think that we're coming back to the question that you just addressed. We can look at the issue from the other perspective as well, not only talking about how democracy and the rule of law help support economic growth and a good business environment, but how can increased European competitiveness, productivity and economic growth actually support our fundamental values. And I think that this is a very relevant and important discussion and question to address, because if we see decreasing European competitiveness, decreasing foreign direct investments into Europe, if we see that our wealth and our standard of living is decreasing or will relatively decrease over time compared to other regions of the world, what will that do to our belief in our fundamental values? If we do no longer have the standard of living to show why these values are worth fighting for, there is, I believe, a long-term risk that more citizens will start to question the legitimacy and the attractiveness of these values. And not only our own citizens, but citizens in partner countries around the world as well. And that's why I think that the focus from the Swedish presidency on competitiveness has been so important, not just from an economic perspective, but also in terms of the fundamental and intrinsic values of the EU.
Ms. Pyrzowski, do you want to add, because this is also part of what the OECD would normally look at?
Absolutely. So no, absolutely. So just on those issues, I mean, these issues are very intricated, and one of the things that we know is that economic difficulties are not good for democracy. That's one of the things that we know. I mean, we know that authoritarian regimes thrive on difficult conditions in democracies. Another way of looking at the issue is when we looked at the drivers of trust. One of the things that came out very clearly from the drivers of trust is that the stable economic conditions and predictability are an important, very important driver of trust also in our democratic governance. So that's also another way of looking at it. Another way of looking at, there are plenty of entry points on this topic, but another way of looking at it is that we know that over time is very important when you're looking at decades. The increases of well-being in democracies is stable, growing, showing that democracies actually deliver on well-being through economic growth and different things, but also because they know how to redistribute, because they learn, because they listen to their citizens, they're able to learn and improve over time. So all these issues are complex, but also showing exactly the same narrative: economic growth, resilience, democracy go together.
Yes, Mr. Prusianu, you want to come in here too?
Quick reaction on this very specific question. 3 years ago, we have generated an own initiative opinions, and we have underlined that the weakening of the rule of law affects the functioning of the society as a whole, and also of the economy, in particular the business sector. From this perspective, we have called the European Commission to do more to concretely measure the economic impact of the rule of law, taking into account both the interlinked substantive and the procedural aspects of the rule of law, notably the key principle of equality before the law. We have also called the Commission to better focus on the rule of law in the framework of European semester, and that means to promote rule of law indicators in order to have a legal certainty and access to remedies for business and workers. And I'm just trying to make a pre-announce. By the end of this year, we shall adopt also an own initiative opinion, which is in connection with corruption in public procurement and its impact on the internal market, which will highlight how corruption and the lack of rule of law undermine the mutual trust that is underpinning the internal market.
Thank you so much, Mr. Prusiano. Now I think I'm going to move to one concluding round of comments from all the panelists. We have in the discussion paper, so that's my suggestion for point of departure, problematized a little bit the question of when fighting the declining rule of law or democratic backsliding, sometimes there might be a risk that we are conducting policies in silos or in different tracks. And how can one then foster, the better cooperation between different organizations or indeed different instruments? That's my proposal for a question for you to reflect upon, but of course you're also free to add whatever final reflections you want to have if you're now looking to the future on how to improve our ways of working. We start with you, Ms. Thorgisdottir.
Thank you. I just want to remind us all that democracy, rule of law and human rights are for individual freedom and political liberty, and it's not conducted from above but from below. So when talking about freedom of expression, it's the touchstone freedom of all other freedoms. Without freedom of expression, there can be no other liberties. So in my personal capacity, I want to thank Ms. Schröder for her input on behalf of the European Federation of Journalists, because I think, given the European Court of Human Rights case law, in the case of Goodwin versus the United Kingdom, the protection of sources is absolutely crucial for any journalism. And in fighting corruption, in creating a more competitive environment for businesses, also little businesses, not only oligarchic conglomerations, but little businesses, is depending on an open criticism and discussion and analysis. So the media freedom, journalistic freedoms can never ever be mitigated or underestimated, their essence or the essence of any individual to step forward and not censor himself in pointing out what we can do better for our societies, for the benefit of all.
Thank you so much, Ms. Thorgisdottir, for this very strong statement. And I'm now moving to Mr. Prusiano.
From our perspective, our main way of reinforcing cooperation between those who uphold the rule of law is by steering debates and facilitating networking in between civil society actors beyond specialists throughout our country visits and various events on this matter. But this is, of course, not enough. To upgrade cooperation in between like-minded actors, much more should be done to create coalitions beyond institutional boundaries. We need more space where the CSO workers, journalists, legal professionals, EU institutions, national and regional authorities meet and exchange. And from this perspective, we have proposed the creation of a forum to allow all such like-minded actors to exchange and identify collectively how we can advance together to better defend our democracies.
Thank you so much. Ms. Piszowski.
I will rebound on that in a second because I think it's a major aspect, but two things on my side. If we had to prioritize and focus our actions to defend democracies, I think we have to separate what is reinforcing the basics of our democracies, and there are always problems with democracies. They are never perfect by definition. So protect what we have, but also look at the cutting edge, because it is possible and probably likely that the threats that we have today, the big threats that we have are coming from cutting edge issues. They are coming from the spread of mis and disinformation, the rights on digital which are not followed. They are coming from these big things that are affecting even the most advanced of our democracies, even the best performing systems. Now, to rebound on what was just said, I believe also that it's actually the time of a new partenariat between civil society, media, governments of a new form, because it didn't exist, because this was stabilized in the past. And this requires a new thinking. And I want to give an example, a recent example that struck me in that regard. We had a number of experts group were working on mis and disinformation and how to put in place the policies to fight mis and disinformation. And we had around the same table freedom fighters, journalists, and people from intelligence agencies. In our traditional democratic system, this would have never been seen. These would be people opposing each other all the time, and like journalists trying to find information from intelligence agencies and fighting, etc. Now they were like in the same room trying to find the solutions. And this is the new type of partnership that we're looking at, and how to ensure the solid governance of that in the future. Thank you very much.
Thank you. Excellent. And Ms. Schröder.
Yeah, to follow on the cooperation, I completely agree what all of you have said. Thank you very much for the importance of protection of sources. I've been working 30 years defending journalists, and I have to say the beauty of the last years has really been a much better, more qualitative cooperation with civil society. We've never had that before, because civil society realizes without journalism there is no democracy. Politicians realize it, but there is, of course, ingrained a difficult situation. But I feel, and that's what I said before, but I want to repeat it, to have this lip servicing, to keep saying we are for media freedom, but not doing it, doesn't help the trust. We have also, when it comes to trust, we have to say in countries, specifically the Nordic countries, where there is a big trust, specifically in public service media, there is a big trust in institutions. But we have, and we have seen that with COVID, with Corona, there has been an eroding trust, and the journalists have felt it. In Germany, for example, which is on media freedom issues still rather well, but there have never been so many attacks against journalists during Corona. In the Netherlands, public service media, a trusted media, they had to hide their logo so that their stuff would be protected. So we are really living in very strange times, so I think this cooperation is important. I just, last point, want to mention the big elephant who is normally in the room or not in the room, which of course are the big platforms, which haven't helped when it comes to disinformation, when it comes to creating all these echo chambers, when it comes to polarization, really points that are very dangerous for the future. And I think distribution is very important, but fair distribution is more important, to not have this gap of polarized elites and people who don't have anything getting further, because that helps the people who are against democracies.
True. Very important points. Mr. Blomqvist.
Thank you. Well, I can just agree with the previous speakers regarding the importance of dialogue and cooperation. And I think to avoid working in silos, we need to recognize what each societal actor brings to the table and what their perspective to this issue is. And take, for example, the fight against corruption. To start with, for businesses, it's important to maintain a high ethical standard and responsible conduct in their own operations, both within the company as such, but also throughout the value chain. From public authorities, you must at the same time address the demand side of bribes and other types of undue influence, and see to that the public servants are not asking for or accepting those kinds of remunerations. And then again, from journalists and from civil society, there's an important role in holding both companies and the public authorities accountable for this work, and also in ensuring that there's information sharing, highlighting the systemic risks that both business sector and governments and the public authorities need to address. So there is really an ecosystem there that I think we need to recognize and develop.
Well, thank you so much. And I think this panel really has broadened our perspective, has brought in new items on the agenda. And I just want to say that let's give them a big round of applause. I think we've learned a lot today. And the good thing about it is that tomorrow we will continue. There will be two panels that I think will be extremely promising about fine-tuning the instruments, but also even more looking forward. I take this opportunity to thank all our online viewers. Those of you who follow this on the Presidency web, please, you're welcome back tomorrow again at 9:15. To all of you in the room, I have some information to give you as well. Thanks for your patience throughout the day.